That's forever. Okay, it's 1:30. It's time on our schedule for a road vacation hearing. Here we're going to be hearing file BS 0002-21. And before we start, I want to ask if anybody has a visual or hearing impairment they need help with. See no one. Hopefully, if you can't hear, you couldn't hear what I said. But see no one, we'll go on. We'll call for potential conflicts for the commissioners.
Commissioner Connolly has no conflict. Commissioner Radfeld has no conflict.
Thank you, Commissioner McDonald. I have no conflict. You have the order for the hearing available, so you can read it. So pay attention if you went to the board. This is the way this is gonna go. It's like a regular planning hearing. Staff will present the report. The applicant will provide an overview of the project. We'll have public testimony. There's gonna be a place in there too for the public testimony. We've got some attorneys that represent different parties that may want to speak. And then we'll start out with testimony in support, testimony that's neutral, and testimony against. Oh, and then we'll come back and towards the end, we'll go ahead and close for Norther, or we'll do rebuttal and close for no further public comment and deliberation. So with that, I will turn it over to staff. Jason, there you are. Staff to go ahead and begin.
Thank you, commissioners. This is Jason Johnson.
Oh, wait a minute. Sorry, Jason. One thing.
Real quick, everyone. My name is Bill Wilson. I work in the prosecutor's office, and I'm handling this matter advisory board. Just for those, I think you guys probably all know this, but just for clarity's sake,
we can't hear you.
Know,
Understand it.
you guys, I'm sorry. There's a ton of people in here, so I'm sorry. So we are here on remand from the district court. We've had one of these hearings before. I assume everybody knows that, but I do feel it's incumbent on me to let you know. The main reason that the district court remanded was because the board did not allow public testimony regarding our former road and bridge director, Steve Clack, and his involvement with Green Enterprises, and which violated the requirements found in Idaho Code 40-203 to consider all related information with this file, and that rendered the board's decision arbitrary in that. Therefore, I'm recommending to the board and hoping that everybody is allowed to provide any related testimony that they see fit. Paying particular attention to Mr. Clatt and the Road and Bridge Department's recommendation. Any other topic that you feel has bearing on this matter, because the statute requires that we accept that information. The heart of the matter is the public interest, and so I would ask that you keep your targets or your information targeted on that topic. But again, you have broad discretion to discuss. The original hearing is still part of this file. Also want to let that be made known to the board itself, so when you guys deliberate, you can reflect back on anything that was said before. And with that, taking these out of the way, now I think we can turn it over to Jason.
Thank you. This is Jason Johnson, Bonner County Planning. We're here today to discuss file VS 0002-21, Title 40 vacation of a public right-of-way. So the petitioner in this case is seeking to vacate a portion of a dedicated right-of-way that's labeled as end of Camp Bay Road, shown on the submitted site plan in this file. The vacation area is approximately 2,550 feet, about 2.93 acres of Camp Bay Road. So on the screen there are the dates that the required noticing was done on this file, as well as a scan of the submitted site plan. This is a zoom of the site plan to the area in question. The site is zoned rural 10 and its land use designation is rural residential. Natural features on the road are fairly unremarkable according to county GIS. There are some slopes at the end of the road going down towards the water. And the soils in the area are all Ponderay hoodoo silt loams, which are not considered prime farmland. This is a list of the agencies that were noticed in the course of reviewing this file. With regard to agency notice, it would be good to review the noticing requirements under Title 40. They're different than other files often reviewed by this department. Agencies are not required to be noticed under state law. Points F and G are a copy paste of the state code. The only exception is the underlines that were added for emphasis. Landowners of record abutting the land to be vacated need to be noticed, but agencies are not required to be noticed. As of the preparation of this file, almost 50 comments were received. They ranged across the board, ranging from the county has maintained the road for 40 plus years. The road does establish public access to Lake Ponderay. The road is not and has never been a public access. The road does not reach the ordinary high water mark and therefore cannot be a public access. The proposed road improvements will be a benefit to the residents in county. Relocating the road will provide for greater protection of Lake Ponderay. The gated road is not in the best interest of residents who live on or around the dam. Some comments that were submitted appear to be related to ongoing litigation between landowners. There were comments submitted from Idaho Fish and Game, which object to the proposed vacation, and those were included in the record. Those showed up late. There was a petition submitted with several hundred signatures opposed to the application here. And there is no provision in Bonner County Revised Code for the consideration of petitions and land use decisions, but that was added to the record. We did receive comments from Matt Mulder, PE, Road and Bridge staff engineer, who submitted comments on behalf of Bonner County Road and Bridge. I'm just going to go ahead and read those into the record here. Mr. Mulder writes, the applicants have signed an agreement with Bonner County to improve Camp Bay Road through the locally funded improvements program and placed money into an escrow account to fund a large portion of the project. This will provide a reconstructed and asphalt paved road from Sagal Road all the way out to the proposed vacation. Camp Bay Road will be greatly improved for all citizens who utilize the road. The applicant is proposing to construct a turnaround for Road and Bridge Department use at the property line where the public right-of-way will terminate if vacated. An easement for this turnaround will be surveyed after construction and dedicated to Bonner County. The applicant is proposing to provide legal access to all citizens beyond the vacated portion of the road. These easements, along with a completely reconstructed and improved roadway, which will include asphalt, will be an improvement over existing conditions. The new asphalt roads within the proposed subdivision will be maintained by the HOA with a road maintenance agreement in place. The existing citizens who live beyond the vacated portions will benefit from this maintenance, which will extend further than county maintenance currently does, reducing the cost to existing citizens by reducing the portions of private road they must currently plow out to the county road. On February 10th, an addendum was submitted to this by Mr. Mulder. I'll just go ahead and read that into the record as well. Based on the recent claims from the citizens that Camp Bay Road goes to the high water mark, The Road and Bridge Department conducted additional research to attempt to locate documents which corroborated or negate this claim. The 1909 handwritten viewer's report for Camp Bay Road does not specify a termination point, and the viewer's report hand-drawn maps and the 1939 and 1974 Metzger maps do not indicate the road going all the way to the high water line. However, the 1909 field survey notes of the viewer's report of the road show TP on beach at high water line. In this case, TP likely stands for turning point, a common surveyor's term. The question of whether or not Camp Bay Road provides public access to the water is undetermined by our research. This opens up the discussion on where the high water line was in 1909 before the dams were built in comparison to the current ordinary high water line. The ordinary high water line is typically defined as the line on the shore established by the fluctuations of water and indicated by physical characteristics such as a clear natural line impressed upon the bank, shelving, changes in the character of soil, destruction of terrestrial vegetation, the presence of litter and debris, or other appropriate means that consider the characteristics of the surrounding areas. The ultimate high water mark made during flood stages does not define the ordinary high water line. The determination of the historic high water lines are outside the scope of the research that Road and Bridge Department has conducted, but we are aware that surveyors are looking into the issue. That was the comment that he submitted there, and this additional comment did not change the departmental support for the applicant's request for a road vacation. At question here today is an easement, and per Donna Gow, Bonner County Assessor, the assessor's office does not value easements. And this is a proposal to vacate a county-owned easement. So this proposal has been reviewed for conformance with Idaho Code 40-203. And the petition to vacate this platted area complies with all state procedures set forth in Idaho Code 40-203. So per this code, the commissioners may, by resolution, declare their intention to abandon and vacate any highway or public right-of-way, or to reclassify a public highway as a public right-of-way, where doing so is in the public interest. Staff concluded this project is consistent with Idaho Code based upon the following: that this proposed vacation will take the roadway out of the county maintenance system and it will become privately maintained. This will have the direct effect of reducing the county road budget obligation, and in turn, it will reduce the obligation of Bonner County taxpayers for road maintenance. This will serve the public interest. The proposed road improvements include moving the road away from the lake, further increasing setback scenarios for structures and septic systems, better protecting the lake to the overall benefit of the public. The proposed improvements include addressing turnarounds at the gate for a school bus or snowplow. The proposed easements replacing the right-of-way will continue to provide access to property owners beyond the subject area. Future maintenance of the road will continue at the petitioner's expense. As noted above, this will serve the public interest by reducing the obligation of Bonner County taxpayers for road maintenance. So if approved, the conditions of approval here are pretty standard. This is really with all vacations, that the vacation of the above described right-of-way shall be effective upon recording of a resolution by the Bonner County Commissioners granting the vacation, and that the costs for legal advertisements and the recording fee shall be borne by the applicant and shall be paid prior to the recording of the resolution vacating the right-of-way. Approval of this proposed vacation shall be conditioned upon the recording of the proposed boundary line adjustments and easements showing access to the properties beyond the subject parcel. Conclusions drawn in this, again, pretty standard. First, that this proposal was reviewed for compliance with the vacation criteria and standards set forth at Idaho Code, Title 40, Chapter 2, Highways and Bridges General Provisions. Conclusion 2, the abandonment of the public right-of-way is in the public interest. Conclusion 3, by granting this petition for vacation of public right-of-way, real property adjoining the subject highway or public right-of-way will not be left without access to an established highway or public right-of-way. So based on this, staff concluded this project is consistent with Idaho Code based on conformance with the procedures set forth at IC 40-203. Staff therefore recommends approval of the request for vacation. One note here, given the comments from Bonner County Road and Bridge and from the law firm noted on the screen there, staff recommends striking finding of fact number 3 from the staff report prior to adopting any motion. This finding stated, quote, currently Camp Bay Road ends at the high water mark of Lake Pend Oreille, end quote. Based on the information in these two comments, this finding can no longer be declared an incontrovertible fact. It's not supportable. So regardless, approve, deny, just make sure to strike finding of fact 3 prior to doing either one of those things. That concludes my presentation, and the commissioners have any questions?
We'll move on to the applicant's representative. The applicant. By the way, before the applicant's representative comes up, I made a little bit of an error. Instead of going for, neutral, and against, I think we're going to do with this many people, we find it more efficient to go row by row. So when it comes back for public comment, we'll start at the first row and work across and just keep going back and forth until we get to the end. Go ahead.
I honestly don't know. I just want to set this on the keyboard.
That's perfect.
Yeah, thank you. Thanks, Jason. Good afternoon, commissioners. My name is Doug Marfus, 700 Northwest Boulevard, Coeur d'Alene. I represent the applicant, remaining sole applicant, MD3 or M3 Idaho Camp Bay LLC. This is not a new matter before you. You've seen this before. This is the second go around. The issue here is whether or not the vacation of the 2,550 feet of Camp Bay Road at issue is in the public interest. As summarized in Mr. Johnson's slides gone over a few moments ago, you previously ruled that the vacation of Camp Bay Road is in the public interest. You were correct. Vacating the road serves the public interest for the reasons articulated in Mr. Johnson's slides, among those removing the financial burden on the county of continuing to maintain the road, plowing, grading, et cetera. It eliminates the need of the county resources, law enforcement, emergency services, et cetera, to police the road and monitor public safety.
Everyone needs to be respectful of the person speaking, or I'll have you removed.
Thank you, sir. It eliminates an unimproved dirt gravel road that is in close proximity to Lake Pend Oreille and the concomitant risk of litter, pollution, dust, gravel, et cetera, finding its way into the lake. It facilitates replacing a present unimproved road with a far superior road in the after effect. And it facilitates the residential development in Camp Bay that will add potentially millions of dollars of tax base to the county. All of those are reasons in the public interest. And for all of those reasons, the decision to vacate Camp Bay Road was and remains in the public interest of the 48,000+ citizens of Bonner County. So why are we here discussing this again? It's because there was a petition for judicial review, as Mr. Wilson summarized, following what occurred last April. The district court on that petition for judicial review did not rule that this board was in error in vacating Camp Bay Road. I want to make that clear. It didn't say that you were wrong. It simply decided that the record that was made was not sufficient and that there were errors caused by that in the district court's opinion could be rectified with this remand. The court said 3 issues needed to be better discussed. And where the court concluded is it invited this board, and I quote the court's opinion, to take this opportunity to issue a more developed written decision for the county record. The 3 areas or 3 main categories, as Mr. Wilson summarized, that were addressed by the district court were that the written resolution was inadequate because it didn't sufficiently set forth the board's reasoning for why vacating Camp Bay Road was in the public interest. That's number 1. Second thing that the court fixated on was that the board did not address the alleged conflict of interest stemming from Mr. Klatt's involvement or lack thereof in the decision-making process on how Department of Road and Bridges addressed the petition. And interrelated with that, the board did not adequately create a record as to why the failure of Bonner County Road and Bridge on the first application to comment in favor, opposed, or neutral, how that fit into the board's decision-making process. Now, the board's counsel can capably advise you on how to fix item number one. It's an easy fix. Make a better record. Support the record with written findings as the court instructed. The court gave good guidance to Mr. Wilson and this board about how to do that. I don't need to tell you how to do that. Mr. Wilson will do so. The second issue on remand regarding this alleged conflict of interest between the former director of the Road and Bridge Department, Mr. Klatt, is now moot. The board knows this. Mr. Klatt is now retired. Whether Mr. Klatt had a conflict of interest last time or not, you don't need to decide that. You simply need to decide whether or not the Department of Road and Bridge has now expressed in the record an opinion on whether or not the vacation of this road is in the public interest. It has. That's a slide that you just reviewed, summarized fairly, and the Department of Road and Bridge's two submittals summarized fairly the various reasons for the department's now articulated support for the vacation of Camp Bay Road. Which takes us to the last item, and that is something that really wasn't addressed to any great extent the last time around, and that is this question of public access to the lake. There's been a number of comments, and there will no doubt be further comments here today, that the vacation of Camp Bay Road constitutes the loss of public access to Lake Pend Oreille. The district court did not remand on this issue. The district court mentioned in a footnote, and taken in context with that footnote.
Bullshit. Hey, get out. You're out. Please leave. Thank you. Tell the truth.
Don't make up lies.
Okay, go ahead.
Thank you. The district court's opinion addressed in a footnote that the articulation of the Camp Bay Road leading to the high water mark of Lake Pend Oreille meant that it led to the water for public access. And that has been seized upon by a number of well-meaning but ill-informed citizens, some of whom will speak to you today. I'm going to briefly touch on why the notion that Camp Bay Road provides legal access to Lake Pend Oreille is legally, factually, and scientifically incorrect. When the road was originally dedicated as a public right-of-way, it was surveyed in what is called a viewer's report. A viewer's report is a function set forth in Idaho code, no longer existing, but at one point for the dedication of public roads, that would essentially commission a survey. The surveyor would go out, lay out the road in traditional surveying fashion, and identify where on the ground the road was located. This is what occurred with Camp Bay Road in 1909. The viewer's report noted a termination point for Camp Bay Road, and it was surveyed. Jeremy Russell from JUB will speak after I am done and provide you the science behind the surveying and how that process located what is called the terminus point. The terminus point of Camp Bay Road was identified with particularity and has been retraced through current surveying standards to a high degree of accuracy. And what that survey shows is that the terminus point of Camp Bay Road does not reach the elevation of 2,051 feet above sea level. Why is that important? Because the elevation of 2,051 feet above sea level is the ordinary high water mark of Lake Pend Oreille. It's been judicially recognized as such since 1986 and has never been challenged. Conversely, the terminus point of Camp Bay Road is at roughly 2,063 feet above sea level. So there is a disconnect between the terminus point of Camp Bay Road and the ordinary high water mark of Lake Pend Oreille. It is incredibly important for you to understand that the ordinary high water mark is a term of art. It is not the same thing as high water line as used in the viewer's report or as used in a number of the submittals sent in terms of public comment. High water line is irrelevant. The ordinary high water mark is that point on the ground where private property ends and state land begins. The bed of the lake being the state lands, everything above that elevation is private property. That distinction must be made. The area between the ordinary high water mark on the low end and the terminus point of Camp Bay Road, as Mr. Russell will tell you, will consist of approximately 50 or so linear feet. Though there is no doubt from the public comments that people have from time to time used Camp Bay Road to lead down to the area of Camp Bay, walked, ridden bikes, parked vehicles, and recreated in the lake. When they were doing so, the transition from the end of Camp Bay Road to the ordinary high water mark, they were crossing private property. It is not a public access. But here's what is more important than anything else in this entire analysis. And I'm sure you're going to hear a lot of public comment about this public access to the lake equation. It doesn't matter. Even if the road were such that it went all the way to the ordinary high water mark, and even if the road were such that it did provide public access, Idaho Code Section 40-2031 provides the board with the authority to abandon, and I'm quoting, abandon and vacate any highway or public right-of-way, including those which furnish public access to the state and federal public lands and waters. Therefore, you don't have to decide where the ordinary high water mark is, even though it's already been judicially declared. You don't have to really decide where the terminus point is in relation to the ordinary high water mark, because at the end of the day, you have the discretion, if it is in the public interest, to vacate Camp Bay Road as the petition requests of you, as you've already done once correctly and simply need to do again with an appropriate and more robust record created. Unless any of the commissioners have any questions, I will yield the podium to Jeremy Russell from JUB Engineering. He will show you some slides, some data, and some further information. I thank you for your attention.
Thank you, Doug. How do I operate the PowerPoint presentation up here?
Is that your presentation?
It is indeed.
Okay.
While he's setting that up, I'll introduce myself. I'm Jeremy Russell. I'm the survey manager with JUB Engineers. I have been surveying for a little over 30 years. I've been in North Idaho for 22 years and have been with JUB for about 17 and managing that department. And one key thing I think I'd like to note is, while I represent M3 now, I've analyzed probably 100 to 150 of these types of roads throughout all of North Idaho. And the vast majority of those, I was on the other side of the fence. I was working for highway districts, municipalities, and that side trying to establish and doing road validations and analysis. And so, my work, while I was working for a developer, my work is independent. My opinions are mine and not influenced, by anyone other than my professional background. So let's get started. Let's see if I can do this. I'm not seeing the mouse. Here it is. I got it.
And then just a second. And just page up, page down to let you know.
Very good. Very good. Thank you. Okay, so a history. This is a compilation of a couple of GLO plats. These were put together in the late 1800s. Kind of gives you a picture, of what things looked like back then. Obviously, a very rudimentary sketch, the original mapping really of this area. Shows Camp Bay. You can kind of see it on the edge of the paper, and then it kind of traverses, in the area and the valley, kind of going up to the northwest. I thought this was kind of a neat map, to kind of lay this foundation for when this road was constructed, because as you can envision, this was settled, right? I mean, this is the late 1800s, early 1900s, and you have settlers coming from all over the place. Setting up shop, they're building their homes. They're starting to farm. They're plugging into communities, and as they're doing that, they start building and using wagon roads and horse trails and different things, and creating this network of thoroughfare. Well, at some point, a group of them get together and said, "Listen, we're getting enough of us out here. We're doing enough. We have commerce going on. We need to get to town, and we need to get to the post office. We need to get to the store, and we need to do these things. Let's get together and go to the county commissioners and see if we can build a public road." So next is what's called a petition. And so this group of people get together and they say, we're going to go to the county commissioners and we're going to petition for a road. And we like you, the county commissioners, to help us do that. And part of that is acquiring right of way. Part of that can be financial support. But really, it's a bringing together of everyone that needs it, recognizing the need, and then the commissioners approving that process going forward. So they make their petition. They get a few, however many people it was together. And the commissioners authorized the road to be viewed and surveyed. And so it goes to the next step. This was in September of 1908. And so the winter goes by, and in that last meeting, the commissioners identified viewers. Mr. Marfus touched on what a viewer is, and really a viewer is intended to be a body of people. And I've seen it as low as 2, which in this case it was 2, and I've seen it up to like 8 or 9. But the commissioners identify these people, and their job was to go out to this area. In this case, we have about a 3-mile corridor that was being analyzed. And so they send the viewers out and they say, we want you to identify the best path. So go and look and find, from a grade standpoint, from a convenience standpoint, and from a cost standpoint, go out, identify that route, work with the surveyor, and let's, memorialize that and see, what we can do. So that's exactly what they did. They went out, and there was, there was 6 of them listed. That little excerpt on the lower right was an excerpt out of the field notes. So you have the top 2 that were the viewers. Then you have the chainmen. Those of you familiar with survey, those are the guys that were actually holding the tape on the ground, doing the measurements. And then you have the axemen that were cutting the line as they went through the route. And then there was the surveyor is not listed for some reason, which is a bit unusual, but he is listed here at the bottom, John Ashley. So you have this group, they go out and they say, okay, let's find the route. And sure enough, they survey the route, from one point down into Camp Bay, following wagon trails, following, different points of reference, and getting down into the bottom. And then when they submit their report, survey was done, as you can see, in March, March 6th, 7th, and 8th. And then the report was filed in April of that same year. So then they write this little note at the bottom. It says, this road will give the people in this vicinity an outlet. At present, they have no feasible roads and no means of getting to a post office. So they're sending that back to the commissioners saying, yeah, we went out and viewed it. Think it's a good idea. This road makes sense. This is our opinion. Let's go forward. I didn't include it on this because it's superfluous, but there was a note that said there was no damages, meaning all of the people that were a party agreed, yeah, we need the road, and we're not willing to charge the county for the right of way to make this happen. So as a result of that survey, there was some mapping created. And this on the left side is a bigger view of the area of the map. And just for reference, I'm going to step over here really quick. The part that we're talking about vacating is from right here down to Camp Bay. And then the road actually continued on out of that section, but that was the end of that map. So you have this map created, and the numbers are stations from the survey notes. So they go through, the viewers and the surveyor, and they're going through and they establish stations. And so some of them might be 200 feet long, some of them might be 500 feet long, but it's just whatever the point of convenience was for turning their traverse and kind of creating that general alignment for the road. They get down to the bottom, and as you can see in the blow up, the terminus point, there was a reference earlier that was called a turning point, which there is a turning point in survey language, but in this context, it is terminus point. Terminus meaning end, it's the end of the road. And so I made a note about the tie to the meander corner from the terminus point. They come down through in their survey, they get to the terminus point, and they're making all of these angle points and whatnot. They get to the end, and they make a tie over to what's called the meander corner. In the late 1800s, when they were laying out all of the sections, they set a monument here along the lake because they actually didn't survey into the lake. They set what's called meander corners around. Meander corner was about right in here. And I've got a map that shows it better, but I just want to make reference to that because it becomes important because I describe the next step. So there's a tie, come to the terminus point, there's a tie down to that meander. So let's pause for a minute. And you kind of have a history of the road, the history of the road that was viewed, history of the road that was surveyed. You have these guys that came down through, they established the corridor, they established the road. So now let's talk for a minute about the things that Mr. Marcos touched on, and that is the levels of the lake. So can everybody, is it okay if I step away from the microphone?
Yeah, it'll be good.
So you have these levels of the lake, and Mr. Marcos mentioned 2051 as the recognized ordinary high water mark. And again, as to reiterate, that is the separation between public and private ownership. State owns waterward of that elevation. Private ownership starts upland of that elevation. It's critically important for everything that we're going to talk about after this. That's really important to understand. So, and as Mr. Marcos mentioned, that went all the way to the Ninth Circuit and was judicially confirmed as that elevation. So around 1950, they start construction on the Albany Falls Dam. And so they do two things. They stabilize the lake, because of flooding, but they also raise the high water mark that exists kind of during the summer months. And that raises it up to 2062.5. So there's about 11 and a half feet difference. And that middle elevation doesn't have a lot of bearing legally in what we're talking about. But I think it's really important, as we evaluate this and as we all look at this, when we go to the lake in the summer and we see it, the water elevation is at this 2062.5. So visually, it looks higher than, well, in fact, it is higher than the public-private ownership boundary. It's a little bit deceiving and somewhat hard to understand, but that's the reason for that green line. And what's really important, and I'll show you this in the next slides, is the terminus point that we looked at earlier comes down to a point horizontally that is actually at an elevation of 2063.9, which is about 1.5 feet higher than the artificial high water mark. So I'm going to show you a graphic of that that kind of brings it all together. So this is an overview of the whole bay, and it just kind of shows everything that we've talked about. Black line is the surveyed alignment in 1909. This line here is that tie that I was talking about from the terminus point to the meander corner. It's noteworthy to me as a surveyor that in 1909, he comes to the end of his alignment and he makes this tie to the 100th of a foot. You know, to me, that's indicative that it was a good tie. I mean, he put some force and effort. It wasn't a plus or minus, it was to the 100th of a foot. 100th of a foot is about 1/8 of an inch. I mean, I'm not saying he measured it that close, but he expressed it to that degree, which means he was, really paying attention when he made the tie. So we have this alignment that comes down. So of course I tied the meander corner to the terminus, and then I backed that out, the alignment and the geometry and the notes, back out up the road. And then I compared that alignment to the physical road. So you have this, and again, when they came through there in 1909, it wasn't that they were locating every single curve, every single tiny angle point. It was a pretty good alignment, but it was general in nature. And so they came through, and so when I overlay that, it's actually pretty incredible. In all the roads I've analyzed over the years, this is one of the better ones that I've ever seen. And you come from the meander corner, come up this tie, go back, and it hits all of these angle points, back about 6 or 8. The major angle points are all right on top of those original notes. So it gives me confidence that we're in the right place. And again, that last tie is really, really nice that he did that. And they don't always, make it that easy. So here's a blow up. End of the alignment as surveyed. This is the terminus point. Comes to the end. This is the artificial high water mark. Again, it's a grain of salt because we don't really care, where that's at relative to the legal boundary, but it's important for our visualization. This is summer pool, and this is the ordinary high water mark as adjudicated in the record of the Ninth Circuit. Which is also, I should note, even in my analysis before I saw the Ninth Circuit case, I could tell for sure that the ordinary high water mark was below the watermark today, just because of the impoundment of the dam that it created in 1955. So a couple of days ago, I had in preparation of this, I had my survey crew go out and actually mark on the ground all of these features. So the arrow that's at the end of that red line is the terminus point that we've been talking about. And as you can see, you have this debris line, right? And I'm going to show you my next and last slide. Shows you some of the water elevations that have fluctuated throughout the years. And so you have this debris line that's been created by, high water that has come through there in flood events. And so 2062.5, again, summer pool, and then the 2051, which is about a foot into the water right now. Yesterday, the elevation of the lake was 2051.5. So just about a foot or foot and a half into the water. But this gives you a picture, right, of terminus point, the artificial high water mark as it exists today, for whatever that's worth. And then the ordinary high water mark that's down near the low water mark as it is today. This distance from the arrow to the blue line, the first blue line is about 5 feet. And then from, as Mr. Marcus mentioned earlier, it's a little over 50 feet between those two lines, horizontally, going down the beach. So that's okay. Here, I'm going to go back to this slide. I can use this other one to explain this. Now, can't quite get there, but you guys can see it. This graph represents the water level. They started tracking Lake Pend Oreille levels in 1929. So we don't have it for 1909 in the area when the survey was completed. However, we do have it from 1929 to 1950s when the dam went into place. And you can see in many years where there were flood events, high water events that took us over that 2062.5 today, and probably more importantly, took us up to that 2063.9, leaving debris, leaving an impression on the water that the surveyor, the viewers came down to the water and said, okay, this is the high water line. We're on the beach, high water line. Not necessarily the high water mark that's down here. It's a high water line that we see here that could have been left by flood events. So with that, I would open up to any questions that the commissioners might have.
Any questions? No, right there. Sure. You guys, is there someone else in the applicant's party that needs to speak here? No, sir. Okay, what I'd like to do is, I know we have a few other attorneys here who want to speak. Well, actually, no, is there an attorney that wants to speak right now? Okay, there. Okay, great. So what we'll do is that we'll start with, I think that whole front road on that side is already spoken. Why don't we go ahead and, if you don't have any more questions, we'll move forward. I'm going to open up the public comment. Okay, so we'll start with the front road, the gallon, the glasses that are up front. If you wish to speak, that's great. If you don't wish to speak, that's fine as well. When you do speak, everyone, and I'll remind you this regularly, please make sure you state your name for the record. Start with that very front row on the other side there. You need to speak up if you're going to speak.
I'm good.
Okay, so then we'll just keep going on the line. Anybody up there wish to speak?
Well, I just want to say some, Monica Gunter. I just want to respond, I guess, to Mr. Marfus and the surveyor. Probably Mr. Marfus, when he says this is in the interest of the public, the residents of Bonner County to give this property up. It is 100% not in the interest of Bonner County residents. It is in the interest. It is in the interest solely of the developer. And when that road goes down and meets the bay, right now it's shown as a $2 million+ lot that is taking out of our pocket. We get zero out of that $2 million lot. Now, I talked personally to Randy Green, an owner of this, and he told me 100% that beachfront has always been and known to be by the Green family and Mrs. Scran-Weidendyke, however you say that. It has always been public property. They have always agreed that it's public property, but the father never, he made it sound like it wasn't, so the residents weren't allowed to use it. He pretended that was his, but according to the actual Randy Green, a family member of this property, it has always been considered public property. Now, I don't know how Mr. Marcus and these people could possibly say that it's in the interest of the residents of Bonner County. And our three commissioners are here to represent the interests of the residents of Bonner County, not the interest of a developer to make billions of dollars off this project and take it out of our pocket and not let us have that public access that, according to Randy Green, was always used by the public Number one, for safe haven from the bay. When the lake gets bad, they come in there, they used to park their boats on that beach and sit there until the storm went away. That's public property. And the commissioners, you guys are here to represent the residents of Bonner County, not a $1 billion project that's going on our lake, taking everything out of our pocket. Ruining this road, that's Camp Bay Road. We have paid how many years to plow that road, to sand that road, to gravel that road. They have no business. We are all willing to keep paying for that road. It is not a bad road. It is a good road because we paid for it. And for us to pay half of the paving to this project is bogus also. It's not fair to the residents. That is our land. That is our property. We need to keep it. And you three commissioners are here to protect the residents of Bonner County.
Speaks, can we hold the applause or whatever else, only because we'll be here all night, unless someone wants to volunteer by day. So, okay, moving down the road here, who's next? Okay, then who's the next person next to you? You a speak, sir? No. Okay, well, let's go to the next row right behind you. Mr. Kramer, I think it is. Make sure you identify yourself for the record.
It is. My name is Richard Kramer. Anna, go to the podium.
Yeah, go to the podium if you would, so the mic picks you up really well.
Just want the record.
My name is Richard Kramer. I'm a resident of Sagal, Idaho, and I'm really addressing you three commissioners. You have once again demonstrated that you have absolutely no interest in what is in the public interest. And you're saying, I need to speak about the public interest. Here's the public right here. And they're outside of these doors and they're here. They took off work. They left their homes. They left whatever they were doing to come here and address what you've done and are proposing to do. These gentlemen here do not represent Bonner County. They represent a developer. We are the citizens of Bonner County that you continually neglect. And I hope that come election day, every one of you remember what these men have done to your county.
Here, here. Okay, thank you, Mr. Kramer. Whoever is next to you, take it away. Okay, go ahead.
Need my glasses. My name is Susan Drumheller. I live in Sagal, Idaho, and the public record is clear that the public right-of-way extends to the high water mark of Lake Pend Oreille, which means it provides public access. And it's interesting because in the application documents and documents from over a year ago when M3 was meeting with the county, they made it clear that they understood that this went to the right-of-way. And now that story is changing. But I did bring along the legal description that's included in the application signed by Jeremy Russell that says it goes, the right-of-way goes to the high water mark. And the court made it clear that that means it provides public access. The staff argues that vacating the road will save the county maintenance costs and potentially protect water quality. I missed most of the discussion earlier, but they said $12,500 a year to maintain that half mile. Is that correct? That means it would cost $16.9 million a year to maintain all the roads in Bonner County, 679 roads. That's more than our $9.5 million budget for road and bridge. So I don't think that's accurate. I think that's really inflated. There's no cost benefit. Well, no, there was none in the staff report, but we heard something about that today. If you had to put a price on it, you could start with the $2 to $3 million value for the waterfront lot that would replace what's now the turnaround for the road. The staff report fails to mention water quality impacts from the alternative. A large home site would join several others lining the bay all of which will likely include large fertilized lawns that could result in nutrient pollution in the nearshore area, contributing to weed growth and algae blooms and generally less clear waters. Also, next door to the west will be a large paved parking area to serve the private gated developments, community center, and large community dock system. This will increase stormwater runoff, all heading to the lake. Compounding this is the recent logging of the land for development and the building of roads, all to be paved, all increasing stormwater runoff to the lake. The Camp Bay Road turnaround is a minor player among these larger pollutant sources, and any stormwater from the turnaround can easily be mitigated. The end of the road, the turnaround, could be moved further upshore, and a native vegetative buffer could be planted to act as a filter for any runoff from the road and to serve as a model for protecting our lake. Neighbors opposed to the road vacation say they will form a nonprofit stewardship organization to care for the 50 feet of public waterfront. And I offer to volunteer my services as a grant writer to assist finding grant funds to address any stormwater concerns resulting from the road. The present and future citizens of Bonner County will benefit more from keeping this public right-of-way than vacating it. Vacating it will not be in keeping with the county's land use plan, which states, quote, "Public recreational accesses and amenities shall not be obstructed or adversely impacted by future development." Thank you. Okay, the comprehensive land use plan says, one of the objectives says, public recreational accesses and amenities shall not be obstructed or adversely impacted by future development. And I think that's about it. Thank you.
Okay, I moved here in 1988. The first 25 years of living here, I did floor installations, tile jobs, countertops.
Steve, would this be better stated? I don't know if this is better stated in deliberation. I mean, it's up to you.
Well, I just wanted it out there.
Okay.
I just wanted it out there.
Okay.
During that time, I did between 10 and 12 jobs on Camp Bay. Some through Monica Gunther when she was at Sandpoint Furniture, some of them did the floor show. I have never been to the end of Camp Bay Road that when you get to the very end of it, that there was not a sign right there that said private property, no trespassing. I don't know if it was legally there. I just know it has always been there.
It was not legally there.
Okay, well, I'm just saying,
That's
that
according to
was my
Randy Green himself.
observation. I just wanted that on the record.
Okay. Go ahead.
My name is Jennifer Kramer. I live in Sagal, Idaho, and I oppose this.
We don't have a mic that amplifies here, unfortunately. That's just for the recording. You gotta make sure, everybody, you gotta really speak up because the phone damages the sound, so.
Is the microphone turned on?
It doesn't. It just goes to the recording.
All right, so I oppose vacating this road. The commissioners, you represent all of Bonner County. We are your constituents. We elected you. And the developer is a single entity, and the only person or the only entity that will benefit from vacating this road. It's been used since, I understand, like 1908, 1909. There's such thing as prescriptive easements that once a pathway is used over and over and over again by the public, it is therefore a public road, a public access. You don't have the right to give away this road. There is no public interest to give away the road. In addition, the locally funded improvement where the county, we have to pay to pave this road is not in the best interest of Bonner County either. That's a Wooded Acres deja vu, and that's a bad decision for the constituents of Bonner County. This is your opportunity to do what's right by the citizens of Bonner County. This is your opportunity to not vacate this road, but to keep access for all of those who want to use it. And you will be held accountable, whether you run again, whether you stay in this position, whoever down the road, you will be held accountable for your decision today. But I request that you think of the public in what's truly in the public's best interest and not a single entity. Thank you.
Can you state your name again? I didn't get the first name.
Jennifer.
Jennifer, thank you. Okay, who's next? Nobody else in that row? Let's move to the next row right across. What? Oh, well, we'll get to the wall later. Be patient, please. Sir, do you wish to speak? No, how about the person next to you? Go ahead. Make sure, no, you don't, okay? Nope, okay, we'll go right here, the gentleman with the camouflage vest, no. Okay, moving fast, Asia, you want to speak? Okay. Person next to Asia. So that is Cheryl,
Okay,
you know the drill.
I know the drill. Cheryl Kins, I don't have a lot to say, other than I'm totally opposed in the strongest terms to vacating a portion of Camp Bay Road as set forth and requested in the file. This is the public's property. And you, as a Board of County Commissioners, have decided that keeping this real property is not in the public interest. On what basis did you decide that without taking a public vote on the same? I submit to you that I believe you would find the majority of the public whom you have been elected to represent would consider your taking and giving valuable public real property, especially that provides lake access, to developers, indeed a taking, not a taking of private property, but a taking of public property. Tyrants do such things without asking or considering the people under them. My parents owned land with Pend Oreille Lake frontage in Trestle Creek. A map showed that before the Cabinet Gorge and Albany Falls dams were built, the land extended a few acres from the current high water mark out into the lake. So, and you showed previous out in the lake. I'm surprised that it ended up there, or if it did end up there, people still walk down to the lake. So as was brought up, there's a prescriptive easement, there's adverse possession. If people have used it over and over throughout the years, I'd say it's public. I have no doubt that the Greensland also originally went out beyond the current high water mark into the lake. If anything, the public needs more lake access as this area has continued to grow. It's too bad and very sad that former county commissioners did not have the foresight to buy up and set aside land for more public lake access and parks. We're running out of it. And it's more valuable to us natives that have lived here forever than the money. Right. There are things more valuable to us. In conclusion, I wholly favor and recommend the following new motion to deny. This is the new motion for you guys. I move to deny this petition file BS 00002-21, a petition to vacate 2,550-foot portion of Camp Bay Road based upon the following conclusion. It is not in the public interest. The decision is based upon evidence submitted and testimony received at this hearing. This action does not result in a taking of private property, but it would be a taking of public property. Thank you.
Who's next? On the other side, Cheryl. Who was speaking? What about the person? Do you want to speak?
Hi, my name is Melissa Dawson, born and
Melissa,
raised
you
here.
go to the mic, please.
My name is Melissa Dawson, born and raised here. I yield my time to Toby McLaughlin when he comes up here.
Okay. Thank you, Melissa. Let's see, we get to the end of that row. Let's jump back a row then. Mr. Clapp.
Steve Clapp for the record. I am the former Bonner County Road and Bridge Director. But before that, I started off moving out to the Garfield Bay Peninsula, which Camp Bay is located on, or the Camp Bay Peninsula, which the Garfield Bay is located on, but I moved out there in 1956. Really, I've been familiar with this area and this territory most of my entire life. I went to work and worked for Green Enterprises in 2011. Came to work for Bonner County in 2015. Declared to Bonner County at the time who my private clients were. And with every new election and every board, reviewed with them the clients that I had, with always a statement and asking, as county policy, personnel policy requires, asking for their approval and describing what I did, and that there was no conflict with what I was doing for Bonner County. My first job with Bonner County was a recreation director, and with that, I worked for accessing, enhancing, improving, securing public access. Went to work in 2017 as a road and bridge director and continued to do consulting work to Green Enterprises. When the Green Enterprise land went under contract sale to M3, I was aware of it. I have never done any work for M3. I continue to do work for Green Enterprises. But in the 10 years that I worked and continue to work now, nearly 11 years with Green Enterprises, I honestly never heard one word ever said about public access in Camp Bay. I did have to talk to Ralph Green and tell him that taking a gun down to run people off the beach was truly a very bad idea. He did protect it. It was posted at all times, no trespassing. Whether that was correctly posted or improperly posted, including the sign that I put up in 2013 that declared it was Homestead Beach and no trespassing, which was placed, one of those was placed directly at the end of the cul-de-sac. That may have been improperly placed, but it was at the instructions of Green Enterprises for placement. Heard no protest. I'd never, ever from Green Enterprise heard anything from any of the family members about public access there. When this matter came up, when M3 was under contract, I think I was first contacted by Alex Brownlee about the idea of doing a road improvement, what we refer to in the road department as a locally funded improvement project. And that is one where the landowners put up some money, the county puts up some money and generally more work and improve the road for a specific improvement. At that time, I declared to Alex, I have got a conflict of interest here. We will turn this project over to Matt Mulder, the county engineer, the road engineer, and to Jason Top, who was at that time the road foreman for the district that included the Camp Bay area. And that, I believe, was the very end of October of 2020. Or the very first, we had one conversation that I think Alex and Bill Brownlee both were on, and Matt and Jason and I were on. And we talked about the processes that the county goes through for a locally funded improvement project. And once again, I reiterated my conflicts of interest very clearly, that I was stepping completely aside, recusing myself from that, and that all conversations would be directed toward Matt and include Jason. And in December 15th, I do believe, was the day with the road department. I met with the road foreman and the county commissioners and brought this subject matter of a locally funded improvement project to the commissioners, at which point I told them very clearly I had a very definite conflict of interest because I was engaged as a consultant, which they were aware of, to Green Enterprises selling the property, that I was completely recused and would have nothing to do with the project of any shape or way or form. And that it all continued to go back to Matt as the engineer and Jason, who went on to be the assistant road director and then is now the road director. But I really and truly was completely hands off. I'm not a principal in Green Enterprises. I have no proprietary interest in Green Enterprises. I have never done consulting work to M3. So because I really felt like I've kind of gotten skewered recently, that I just wanted to clarify that my conflict of interest was obvious, it was there, it was clearly declared, and I took it very seriously and completely stepped aside from any involvement in this project. That's what I wish to say. Thank you.
Thanks.
Person, there we go. Make sure you identify your name for the record. You're getting tired of hearing that.
Christina Kingsland, opposed. I think that the story that the surveyor told about people getting together in 1909 to solve a problem in their county was a beautiful story. Government obviously was working at that time when people could come together and look at what is in the best interest of everybody. This project has a lot of problems, and giving away public access is just one of them. I moved here in 76. My family's never owned waterfront. I've never owned waterfront. I didn't own a boat until 2008. I had an inner tube out of a tire, and we went to public access, but it was a really good life. And now when people move here and it's their second home and third home, and they have a 100-foot wide lot and everything is no trespassing, no trespassing, I'm personally offended. So I apologize if I come off as emotional. I've been a realtor here for 17 years. And when I want to go sell a development, I want to have something that has some good underlying documents. I don't want something that's a whole lot of lot line adjustments and minor land divisions and a lot of stuff that's going on in Bonner County right now that is not in the public interest. We don't have to sell our county to the highest bidder. People come here because of the quality of life that we have, and you commissioners are the gatekeepers on this quality of life. The comprehensive plan is set up to give a voice to the people and to help guide you in how you enforce those laws. Milton, what you do in this county is so important. Thank you for your service. I would like to give you more, I'd like to direct you back to who you work for, and you work for the people of Bonner County. And as Susan read, the goal for public and private recreation opportunities are recognized as a major county asset. I think that's accurate when you look at the website that shows what the value of this lot is. It's a public access, it's a public asset, whether you go all the way to the water and enjoy the water or not. I had a really nice conversation with a gal named Teresa who lives just right up the road from there. She's in her mid-70s and she lives on Elliott Bay Road, and she likes to take a walk down to the lake. She's not stepping in the lake, but she's walking down to this beautiful place and taking a turnaround, and it would really, really adversely affect her enjoyment of her property and her retirement if all of that goes away and she walks down the road and then there's a big gate. This has not been a community of gated. We're not a gated community. We're a friendly community where the guy on the waterfront lives in $1 million house and the guy behind him lives in a $200,000 trailer. All those numbers are kind of been fluctuating, but you get what the picture. And one guy pulls the other guy's car out of a ditch, and one guy shares a beer with the other guy. And we've been friends and we've been neighbors and we've had a community. And a gate and a fence is taking that away. I think there's a way that all people can get what they need here, and we could have a real development and we could have public access. And all of this would fit if we had government that worked for everybody and not just the highest bidder. Thank you.
My name is Sharon Frazier, and my family and I own property on the north side of this development. We've been there for 31 years. We oppose closing of that road. We've used the road, and again, whether we've actually gone in the water or not, we've used the road for our ATVs, walking our dogs, to go down and enjoy the view. I have one issue, and I don't know if it's relevant. I think the commissioners need to maybe look into it. You said no one objected at the first time this occurred. I don't think anyone was notified. We were not notified. We have property bordering this, and this last attempt at notifying everybody, we did get notified. And at the very bottom of it, it said, The notifications go out for people within 300 feet of the property. That's like maybe, I don't know, 6 or 7 people. I don't know for sure how many, but very few. So that's why nobody was here to object the first time around. Nobody knew. And I thank the Arns for waking us up in time to come and say, this isn't right. This is public property. And like I say, whether we actually go into the water, we still go down and enjoy that fantastic view. This development can gate off their private roads if they want to the sides. It would still, you know, allow us to go down and access the view, the water, the roadway. So.
Sure. You wish to speak?
No.
Okay. We'll go to you, sir.
Yeah, I would.
My name's John Kearns. My wife and I own property on South Camp Bay Road, so we're impacted by this. I'd like to say that when we first bought our property in 2013, Jim Green ran me off the beach. And the beach was festooned with no trespassing signs all over the place. And we just use the property up there in the summer, you know, vacationing and that type of thing. But I've never seen anybody on the beach, that nobody has gone down, in my opinion, and walked around on the beach or vacated or, you know, vacationed or whatever you want to call it. Because Jim Green was just like a pit bull there. And he'd run everybody off. And from my understanding and talking to the neighbors, his dad was even worse. You know, as I don't know, the other fellow said he was, you know, maybe waving a shotgun around or something. I don't know what he was doing down there. But so there hasn't been any public access. And I can understand the public here, you know, thinking that, you know, this is taking something away from the public to get on the beach. Well, the answer there is they didn't get on the beach. But, you know, obviously I'm in favor of it. I think the benefits to the public are the paving of Camp Bay Road. You know, that thing is a dustbin when you drive through it in the summertime. I mean, it was a cloud of dust. And I feel sorry for the people, they wash their cars. And if they're not lucky, you know, another car is going to come by and they have to go wash it again. And the development company is, as I understand, paying a substantial amount of money to pave that road. And that's a significant benefit for everybody who lives along the road, I would think. If I had a property up there on the road, I'd love to have it asphalted. That would only increase my property value. And other than that, I think some of the comments about being able to walk down there, I think that's good. You know, maybe the developers would let people walk down there. I don't know. But that's more or less my comments. I think it's a question of private property rights versus the public's demand to, you know, be able to go across somebody else's land and get in the water or whatever. The attorneys and the surveyor pointed out here where the real water line is. It's 2,051 feet. And that's the official high water line mark. So obviously I'm in favor of the development. I'm in favor of the paving. I'm in favor of the project. So that's all I have to say.
Gentleman next to Sean. You should have your name correct.
My name's Larry Davidson. I'm a lifelong resident of North Idaho. I'm a 36-year resident of Bonner County. I live on Bundle Bay Road, which has no real connection to this, but I do have an interest in this property. I'm opposed to this project for one reason specifically, variety of reasons in general. I've been an attorney for 36 years now, and this is an interesting project. It's an interesting issue in law. I haven't heard of any yet definitive terms as to what TP is. At this point, it could either be turning point or terminus point. There is a difference between those two definitions, legal definition, and that issue has not been decided at this point. What we know in law, and oftentimes issues such as this goes to the intent of the parties. And it sounded to me like the intent of the parties was to have access to the water. And that was indicated in the initial discussions that were given by the proponent, that the landowners and property owners out there at the time that this was granted was that they have access to the water for commercial purposes. There was a discussion of mail, and mail at the time, I believe, came by boat. And the boat had to come to the shoreline, whatever the shoreline may have been at whatever time of the year the boat was coming to the shoreline. Back then, the shoreline was at 2051. It wasn't until the dam came in that it turned to 2062. So if the intent was to use that commercial access of getting the boat or whatever else, I'm not familiar with any other commercial purpose out there. Maybe there was some hay or something that they needed to get to market. I don't know about any of that. All I'm saying is that the issue goes to the intent of the parties, not really the public at large. That's a separate issue. Mr. Marfus is absolutely correct in that none of that technicality has any bearing on this. The bearing is that a grant was given for a roadway. And the county accepted that grant. That grant became public property. It was in the public domain. And we are the public, whether we're residents of the area out by Camp Bay or whether we live in Bonner County at large. I don't know, but we all have a vested public interest in that roadway. My interest in it is something separate and distinct. I've been involved in trails in Bonner County and Boundary County for quite some time now, at least for the past 20 some years. And it just so happens that there are two trail systems out there that are affected by this roadway. One is Gamblin Lake Trail System and the other is Mineral Point Trail System. This roadway is a connector or a potential connector between those two trail systems. If this is abandoned, if this roadway is abandoned, then the connection of those two trail systems would be forever lost. And trying to get another route may be possible at some point, but we have a connection right now that's a connection between those two trail systems. Both trail systems are very popular. Mineral Point particularly is one of the most popular trail systems in Bonner County. But anyway, if we lose this roadway, in all likelihood, we would lose that connection. What we know is the public is becoming more and more health conscious as time goes on. Trails and the interaction that people have on trails becomes more important to them as time goes on. What we also know is that there have been a variety of surveys, a plethora of surveys actually, which indicate that the proximity of residential properties to trail systems has a direct and positive correlation to the value of that property, that people want to be near those access points or have access to recreational activity. And this represents a determination. What's being proposed is a determination that that would be denied. I would think that these advocates for this project would be on the other side of this and encouraging the public to be involved in this. I understand that everybody wants their own domain, but nevertheless, from a public interest perspective, the abandonment of this roadway is to the detriment of the public. That's all. Thank you.
Yeah, well.
Hello, my name is Alan Abermite. My family had been in this county since probably 1905 or so. I myself was born in 1962. Now I've used this lake, I fish it, and when I was a child, me and a buddy of mine, we used to go down right to Camp Bay in our pickup, pull out our 12-foot aluminum boat, slide it right down there and go out in that bay and fish that bay. And we fished it often. Not one time did our pickup ever have a note, "You're not allowed here." There was a time where a guy came down and he did say, hey, but we just said, we're cleaning up after ourselves. We're not making a mess. And he was fine with it. But numerous times we've used that access and never once were we denied it. And also, all of us, we've been, from way back, been paying taxes on this road to keep this road ours. And now you're going to sit there and give it to these guys? Come on, man. What's wrong with you? I mean, think about it. You guys work for us. This is our lake. This isn't Californian's lake. This isn't Washington's lake. This is our Bonner County's lake. And we deserve to have this lake and to use it as we need to and have access to it. So I'm against it.
Yeah, I just want to make sure.
Doug Patterson for the record. Try making this brief. So we're talking about the high water mark as posted now. We're talking about that it being in 1986 versus what the high water mark was in 1909. Now, the amount of information you got with the wavy graph there, that started in 1932, I believe. These dams that have been put in have changed the level of that lake dramatically from what it used to be in the old days. There was a series of dams that have been put in to keep the water coming down from both the Clark Fork and rivers feeding the Clark Fork. Used to flood this area on pretty regularly, not every year, but many years. And now we're talking about the ordinary high water mark rather than the historic high water mark. And historic high water mark is what matters. So where this survey went in, it went to at least the historic high water mark. And so looking at that, you also saw the pictures of the road going down there, which is in spitting distance. The normal roads have a right of way that's on the side of them that is controlled by the county, where they plow their snow and all those things. Those roads down there were just turning around would get you to the present high water mark. Those things said, when they asked for this road to be put in the first place, there were people living there. How did they get there? It used to be that transportation was done on the water. You probably know about the Cabinet Mountains. The town of Cabinet, a little bit east of Clark Fork, used to be the stopping point for powered boats, steamboats. And those boats went all over the lake. Those people that got in there had equipment they had to get in there, tools they had to get in there, probably cattle and other things. They were coming up from the lake. So traditional access to and from that is pretty well established simply by the history. Let's see. The other thing that I wanted to mention was supply and demand. Okay, supply and demand. Now, when you go try and launch your boat in the summer, you find yourself in a fairly long line, virtually every place around the lake. More and more of the public accesses are being shut down. As more accesses are shut down and more population comes in, as well as travelers that want to get to the lake, the value of those properties with potential access goes up, which means that anybody who owns property with potential access to the lake and has control of that property has a conflict of interest in this matter, Mr. McDonald.
Oh, so now we can't have property alongside the lake?
Control of property that runs to the lake, yes. So that said, I think you have a conflict of interest. Thank you.
Just a little. Okay, who's next to the other side of that?
My name is Selma Brisboy, and I spent 2/3 of my 83 years on the Camp Bay Road, bicycling down to the lake, swimming. We had a goal. There was some old piling there. We had a goal, my brothers and sisters, that we would swim in Lake Pend Oreille before school was out. School was out in May. So we did that. I knew all of the greens. I swam with Kate Van Scravendijk, Jean Green's mother. I swam with Jean. My neighbor and I, we have kayaked from there. It's a beautiful spot. We used to just go and sit on the beach to enjoy the peacefulness and the beauty. I would think it's a huge travesty to close off this road to the lake. Thank you.
Thanks.
My name is Barbara Best, and I do not feel this is in the public's best interest to vacate this land. This needs to stay in public domain. This is public property, and as citizens of the state of Idaho and Bonner County, we hold that right, and we need to be heard. And that's why I'm up here. So you're hearing at least some of us say, we don't agree with what you're trying to do. Thank you.
Next, there. Okay, go ahead.
You have to go somewhere else. Good afternoon. My name's Deb Rule, Sandpoint City Councilwoman, if you guys don't already know that. I would like to encourage the rest of the room to stand up and state your opinion, even if it might be shortly, so that it can be heard by the commissioners, so they can get a good feel for how many people in the room are opposed and are not opposed to this development. I was a part of the Trails Mix Committee, where Steve Platt ran that board for a while. And quite often he would point out how there were many county roads that terminated in the water, and we could start a waterways trail, which Larry spoke to. I'd also like to point out to you, if you don't already know it, that there are many streets in the city of Sandpoint that the property owners who reside next to those streets don't really want you to know that they actually terminate into the lake also. Those would include Euclid, Division, Boyer, Olive Avenue. I know that 4th does not. 3rd Street, we actually found the money to put a pier on there many years ago for the people to access that. So this is not unusual that things terminate in there. I'm not going to go on about the high water marks. We've heard a lot of that. But I have a feeling, as Larry said, that whether it's a terminus or turning point, that people in 1909 were not using these artificial high water mark or high water mark terms. They were pretty smart individuals. They lived off the land. They lived through our winters, our summers, our rains, and everything else. They figured out where to put the road to best access the lake so it wouldn't wash away and they wouldn't have to spend more of their county money to keep it maintenance, just like anybody else who lives on the side of the mountain builds their driveway the right way so they don't slide down it in the winter. if you can. And you don't have to spend as much money in gravel. So again, I would like to encourage all of you in the room, if the only thing you come up here and say is opposed or for, to do that so that the commissioners know. Thank you.
Hi, my name is Jean Bansimer. I'm a Sago resident.
I'm sorry, I couldn't hear your name.
Jean Bansimer, and I'm a Sago resident. This is really the last place I wanted to be today. And it's not because I don't enjoy being with all you folks. It's just that I'm really surprised that this is even a question. It kind of took me by surprise when my husband mentioned or saw that in the newspaper this was being brought up, and we went to a meeting about it. I live not far down the road on Sago Road there. So I'm not a long-term resident, but I don't want this place to turn into some of the other places I've lived. And so I think it's very important, the job that you commissioners are doing to protect the area here and to protect what could become like any other town community across the nation that has let growth get out of control. So that's one thing. Everybody said a lot of different things today, and I agreed with all of them. Number one being that the original intent seems to be that in 1908, people got together and said, hey, we would like to have a road. The county commissioners worked together with that to build a road. And I agree with what Gal just said, that they just made it a practical road. Doesn't seem to be a lot of data between 1908 and 1932 to determine what the high water mark was or the low water mark was. I mean, you're starting with a pattern from 1932 on, but we don't know what the pattern was prior to that from the slides that we saw. So that to me seems like it would be a legal question. And I just want to say for myself personally, a couple of years ago, my son, probably about 17 or 18 years old at that time, had a great Mother's Day gift idea. Packed up some kayaks and we went over to Camp Bay. And now my husband had said to me, you know, you're not supposed to go use that area, but I didn't know whether it was or not, but my son really wanted to take me there. So we put the kayaks in the water. There was another family that was there on the beach at the time. They never said anything to us. And we just strolled out into the middle of the lake. This is the two of us. And it was just, wow. There's an eagle's nest not so far, right, that you could see. And it's just so beautiful. And I would hate to see the public not have access to that. Now, I didn't know the folks before that. I'm curious, did they own the land in 1908? The Green family, did they? Okay. So that I wasn't aware of that. But it seems to me that the intent was when the county came together to build that road that, hey, it's so the public can get in there. I think that the developer could help to come up with a good compromise and help to develop that road to maybe a nicer place for that beach, to have like a little beachy area there for the public. It doesn't have to be necessarily an either or. You know, it could raise the property values if you make that road nice for everybody and make that area nice for everybody's use. That's just another thing to take a look at. But, you know, however you slice it, my opinion is I'd like to see that road vacated, and I am a resident, and I will be watching. Not vacate. I would like to not see a gate there, I guess, in my mind, right? Please don't vacate the road. And yeah. And I hope that you do the right thing. I know there's a lot of pressure on both sides, but I hope that you do the right thing that's in the best interest of everybody.
Hi, my name is Jody Frankenbach, and I live on Elliott Bay Road in Sago. What is in the public interest? As we've heard, Idaho State Code Title 40, Chapter 2, Section 40-203, abandonment and vacation of county and highway district system highways or public rights of way, states that a used and maintained public right of way can be vacated by the county only upon formal determination by the commissioners pursuant to this section that retaining the highway or public right of way for use by the public is not in the public's interest. In 1908, John Van Stravendijk, the original homesteader of Camp Bay property, petitioned Bonner County to make Camp Bay Road a public road. This road was built for access to the lake by fishermen, travelers, and other public uses, as the county relied on the lake for transportation to this remote area, as stated by the petitioner's representation. As Bonner County continues to grow, access to Lake Pend Oreille has been diminishing. Camp Bay Road and its access to Lake Pend Oreille has become very valuable to the people who live in the Sagal Peninsula. As we've heard previously, the Bonner County Comp Plan states that public recreation accesses and amenities shall not be obstructed or adversely impacted by future development. Even Governor Brad Little has emphasized protecting and enhancing outdoor recreation opportunities. The staff analysis for recommending projected vacation of the road states 5 points. Point 1 refers to the cost of road maintenance. The roadbed itself, as distinct from the underlying land, is a capital asset paid for by the taxpayers for over 100 years. State law requires a finding that abandoning a public road is in the public interest, primarily to protect the taxpayers' interest in the infrastructure for which we have paid. Regarding the ongoing maintenance costs, the county continued to maintain the gravel road between the April abandonment and November reinstatement, which indicates the maintenance cost is not so large that the county has a compelling interest in cutting this expense. Once the road is paved, maintenance costs will be reduced even further. In light of the value of the road itself and apparently trivial costs of maintenance, the actual cost savings must be quantified to allow a full assessment of whether vacation of the road is in the public interest. Point 2 states that vacating the road will increase setbacks to the lake of building and septic systems. This statement is patently false. Nothing can be built in the easement of this public road. M3's intentions are clear. They intend to place a building lot at the location where Camp Bay Road meets the high water mark. Thus, setbacks will be decreased. Point 2 states that vacating the road will, Point 3 and 4 are also patently false, as they address items that currently exist and are not benefits to the public that result from vacating the road. There's currently a very large turnaround for buses and snowplows at the end of Camp Bay Road, and property owners beyond the green property already have a legal easement to access the property. Point 5 is simply a restatement of point 1, and is basically saying that the savings of a paperclip is worth giving away a Cadillac. Is this really in the public interest? Everyone who's opposed, please raise your hand. Thank you.
Thank you.
Nice. I am Jennifer Arn, wife of Fred Arn, and I want to breathe. Please excuse our emotionalism. This has been our life for the last year, and feelings run very strong on this issue. Okay, so first I want to say that we believe that we've made a solid common sense case not to abandon Camp Bay Road. If there's any doubt, please reread the court opinion, which I have right here. The very first sentence says Camp Bay Road, a gravel road, which dead ends, I can read it right here, but anyway, it dead ends into Lake Pend Oreille, providing public access. It says that in the very first sentence. Okay, not my words, the judge's. Also, whether it's in a footnote or not, she refers to last year's decision based on erroneous information that the lake does not provide public access. It does, whether it's in a footnote or in the main part of her ruling or one of her points, it's very clear. Look up Sanders Beach, which she quotes as case law. Okay, so moving on, simply put, there is public access. The state of Idaho and the court has made it crystal clear. There's obviously a lot of information that to bring up confusion about that, but trust me on this one, it is. Even JUB in their presentation last year admitted that the 50 feet of public access to the lake from the road, they never disputed that and even brought it up themselves. So under no circumstances is giving away public access to Lake Pend Oreille in the public interest, or is it based in law? If you have any doubt how the public feels, look, and I have more to show you later. Okay, as for reports about security concerns, our FOIA request from the Bonner County Sheriff's Office more than dispelled that as a viable consideration. There were only 3 calls for trespassing on the Greens property over an 11-year period from 2010 2021. So we asked the Sheriff's Department about the reports. We heard 22 reports for trespassing where the sheriff was called. And we asked them and they said, we don't know where they got that information. They didn't get it from us. So we did the FOIA request. Of those 3, one of them was somebody pulling their catamaran up onto the beach for a short time. There was a call and then they called back. Ralph Green called back saying, never mind, they left. So that was one of the 3. And 2 of them were Jim Green calling against his sister Kathy, wanting her arrested for trespassing. So that was it. And we looked North Camp Bay, South Camp Bay, and all of Camp Bay up to Sagal Road. And those were the 3 from 2010 to 2021. So that certainly wasn't true. And the sheriff and the county prosecutor has affirmed our right to the beach via Camp Bay Road, staying from the road, going directly onto the beach, not to the private property on either side. Okay. These aren't my words, so sorry. Posting no trespassing on public property. Hunters in here should know that is a federal misdemeanor. And so those signs on Homestead Beach in the lake bed are illegal, punishable up to $1,000 per incident. Okay, so moving along. In the future, if it turns out that there is a security problem, we have offered to install cameras in the future if that should come to pass. We are very concerned about the security of our neighborhood as well. Should the commissioners in their infinite wisdom return the road to the public, it is our intent to form a nonprofit corporation to clean and maintain the beach, improve the beach, install a bench and a bike rack dedicated to Jean Ben Shrivendike Green. And all of this not using public funds, but donations, grants, and working with the County Roads and Bridges Department to make sure everything is to their standards. So please follow the wishes of the taxpayers and voters of Bonner County and keep Camp Bay Road public, maintaining the public access to the lake. Okay, I'm sorry, I'm not done. Now mine. Okay, so I didn't want to spend any time talking about the legal aspect of it because I thought that would have been made perfectly clear, and hopefully it will later on. Also about what a beautiful treasure it is, because I think you all know that. And I wanted to get straight to the point. But I did want to make some clarifications. Our objections have nothing to do with private property rights. This entire case has nothing to do with private property rights, stopping development, or telling anyone what they can or cannot do with their own land. It is not a partisan issue. It's about a public road that legally provides lake access, a road that has been public since it was built with taxpayer money over 110 years ago. We, along with many others, wish it to remain so. Another clarification. In the last hearing, Brad Marshall of JUB was talking about how the width of the right-of-way is just 50 feet. And he says, when you think of developing a public access, 50 feet is not adequate for a boat launch, trailer parking, public restroom, ADA requirements, solid waste facilities that are all needed with public access. To which I responded and was later said as being against the development. I said, and I should have been more clear, nobody needs to develop this land. It's fine how it is. And I was speaking specifically to that 50 feet right there. All we want is to be able to take our 2 little feet across it without interfering with anybody else's private property and go to the lake and leave cleanly, neatly, without disturbing anybody. Okay. Moving right along. So on to the development. With over 400 acres to work with, one would think they could have come up with a plan around our public road, possibly waiting to see if they could get a road vacation first, instead of planning their development and all their plots with the Camp Bay Road privatized and advertising it before their application was submitted last February, or it was even heard last April. That brought severe questions to me. It's also been mentioned that if this road vacation is passed, it will benefit the Bonner County because of all the higher tax revenue. Well, the lots there at Camp Bay, which have already been sold, and there have been a few, have included in their deeds Exhibit B permitted exceptions for all the ingress, egress exceptions. It's a different number on the different lots, and this particular one, item 11, rights of the public, this is excluded on their deed. Rights of the public in and to any portion of said land lying within Camp Bay Road. So they have already paid for these, and this is in their deed. So the idea that it would be less money or that we're all going to be hurting as taxpayers of this county because there'll be less revenue, I think that's kind of bunk. Okay, in response to no neighbors objected, if you have been paying attention at all, you know that's not true. I have in this one, I didn't think I was going to need to do all this, over 650 signatures of, and these are all on record, you have these, of individual Bonner County citizens that citizens and voters that really wish this to remain public. If it's just the nice little sportsman's access that it is right now, they're happy with that. Okay, and this is all in record. And also they stated that no agencies objected. I'd like to touch on those agencies. Roads and Bridges, well, okay, Idaho Department of Lands, both locally and the head of IDL in Boise said that their jurisdiction ends in the lake beds. So, and then clearly this is a fish and game issue. And that was even brought up by, I believe, planning at the last hearing. If you look at the routing slip on the original application and the new and improved one, look who is conspicuously left off that. Fish and Game was never asked for their comment on both of these. So anyway, so that leaves who is here to speak for the people of Bonner County? What agency is that? That would leave our commissioners here. It is you, the democratically elected commissioners, that have that great responsibility to choose what really is in the public interest of the citizens you represent. Please make the right choice against this road vacation, because in the words of our state motto, Esto Perpetua, it is forever.
Who's sitting next to Jennifer?
Hi, my name is Paige Belfry. It's hard to be here today. The little one you keep hearing is my daughter. And we are here through nap time, which, as any of you with kids know, is a big deal. So we're here as a family. I don't have a story of being here for 50 years, but I do have a story of how we found Sandpoint and how important it is to us. My husband and I hiked 1,000 miles on the Idaho Centennial Trail, and that's how we found Sandpoint. And that's how we came to see what a special place that it is. We probably represent a cross section that's not here today because a lot of people my age have to be at work right now. And so when I'm speaking and saying these things, I think we should think about how many other people couldn't be here today to say what they wanted to say, right? My husband and I have the opportunity to be here because we started a business in this town that I feel brings a lot of value here. So we're lucky to be in this minority that can be here today of our age group and working class. Obviously, places like this are really important to us. We hiked the Centennial Trail. After we moved here, we also paddled the entire lake and found it's really difficult to find a place to pull up your kayak on the lake without breaking the rules. And we don't want to see those places go away. These are really important to us and to our little girl and to everybody else who has kids that want to enjoy these places. We are also in a section of the community that is struggling and hanging on by a thread to stay here. We have found the only opportunity for us to stay here is to build our own house, not to hire a contractor to do it for us, but to build our own house with our own hands while we raise our daughter and while we run a business. And these public places that are beautiful make it all worth it. So we would ask the commissioners to represent us and our family's interests and all the people like us whose lives depend on these beautiful places. So please think of us when you're making this decision. Thank you.
My name is Jennifer Wood. My family goes back to 1889 in Gamblin Lake, Glengarry area, full of stories of using Camp Bay Beach. My mom, who's sitting next to me back here, she used Camp Bay Beach as a child. And my grandpa fished those shores. But Mr. Bradshaw, you are 100% correct. In the 80s, there were a massive amount of no trespassing signs. So when Grandma wanted to take me down for a picnic to places that she used to go to when she was a little girl, it was sketchy. We did it anyway, but it was sketchy. The thing is, I've heard a lot today about it not being public access. That could be very true for the past 40 or 50 years. Absolutely. But before that, I have so many stories about using that bay. And a lot of them come from my own family and friends that are still out there today. My great uncle John Anderson built that little church at the beginning of Camp Bay Road, the Church of the Wildwood. And fishermen would come in up there. And many times my husband and I, 3 times actually, we've been out on the boat and that south end of the lake can pick up in a second. And we have been able to pull in and find refuge on that bay. It's an easy access. And with that said, I'm pretty passionate. You saw me here last week talking about the Selly Valley. That's where my other side of the family grew up. That's where I live. You met my boy who came in and talked. You guys had a hard decision. Yeah, he's going to run for commissioner someday.
He might be nuts.
Yeah. He wanted to speak today too. I said, you'll have your time. But anyway, my point being is you had a tough choice to make last week. But one of the winning points, one of the issues was that the applicant wanted to put things back the way they were before. He wanted to go back to the 10-acre zoning he had before. I'm saying this as an example that let's entertain the idea that you think it's private property right now. Maybe entertain the idea of following suit you did last week. And let's go back to when it was private property, before those no trespassing signs went up. Back when we could have a picnic without it feeling sketchy. And the thing is if it is not public property, and I don't know, I'm very novice to politics. I'm not, unlike my 11-year-old son, I'm novice to politics. If it isn't public property, how was it able to be given away? I don't understand that. I don't understand how that quite worked. So it's almost admitting the opposite. I could go on and on about how passionate I am about this, because I really am. I really am. Like you said, there's so little left on this side of the lake. You can't walk to the Green Monarchs to jump in. You know how many times I've gone down to places in Sunnyside where owners have put up private property signs and they weren't legit. And by the end of summer, they were gone, you know? And the thing is, word's out on Lake Pend Oreille. People are coming here in droves. Anytime I want to go jump into Sunnyside, it's Oregon, Washington, places from out of state. So I get some of the concern of people going, well, then the public's going to have access to our area, but so will your local neighbors. My most favorite photo ever of President Teddy Roosevelt was the night before he left office. Anybody familiar with this photo? The night before he left office, and you can Google this. There's a photo of him in the Oval Office with a marker, marking out a map of what he wanted to be our national forests. The clock was ticking and he preserved. I am literally begging you guys, because you have the power in you today, right now. Mr. Connolly, Mr. McDonald, Mr. Bradshaw, you have the power in you to preserve this, to turn back time if you have to put it back to the public. Give us what we've had in the past, and you'll be so appreciated. Thank you so much.
Hi, my name is Nick Belfry. That's my wife, Paige, spoke a moment ago, and my daughter in the back. I have 2 points, and one is that one of the points for vacating the road was in order to protect the lake. And my question is, do you really think you need to protect the lake from us? If you want to protect the lake, maybe we should regulate what people put on their lawns, you know? My other point is that if you do approve the vacation, you haven't heard the last of this. Do you really want to fight all of these people and make that big of a deal? My third point is that you 3 gentlemen today have an opportunity to either be heroes or villains. And I really hope you choose to be heroes. So, thank you.
We don't have that.
Yeah.
All right, my name is Toby McLaughlin. I'm a local real estate attorney here. I do represent a landowner who owns the last property on South Camp Bay Roads, the Lotwellas, and they access their property through South Camp Bay Road. So the first thing I'm going to say is on behalf, they access their property through Camp Bay Road that then hits South Camp Bay Road and they get their property that way. We had an entire litigation on whether or not they had the right to use that road, and it was confirmed that they do. My first comment is just on behalf of them, which is to say that whatever the commissioners do, if the commissioners decide to grant the public or the vacation public right of way, they have to preserve the rights of all the owners on South Camp Bay Road. That was addressed at the last hearing. I think it's probably already addressed, but I would be remiss if I didn't bring that back up. That is Idaho law. Taking off my hat as the Lavalas attorney, just speaking on behalf of myself, because I had the opportunity to litigate that case, I learned a lot about Camp Bay Road and South Camp Bay Road. I'm going to address a couple of those points for the sole purpose that I want to make sure the record's as clear as I can make it as to what rights exist and what rights do not exist. Very first and foremost, I want to address the issue of whether or not the right-of-way extended to the water, extends now to the water. Now, what we know is there's a viewer report. It was put up, part of it was put up on the screen earlier. I think Mr. Russell put it up there. In that report indicates very clearly, it says the TP, which I would assert is the termination point, it's the end of the easement, end of the public right-of-way, ends, quote, at the high water line. So you have to remember what they were talking about in 1909 was the high water line. The high water line, of course, we've heard about this. It was pre-dam. And what we're talking about is, and this is, you know, Mr. Marcus is correct. It's already a resolved issue under Idaho law. The water line, the lake level pre-dam is 2,051 feet above mean sea level. We know that. That was the elevation of it at the time. The new dam, once the Albany Falls Dam came online in 1953, the level of the lake was raised to 2,062 feet, or 2,062.5 feet. Is actually, this is straight out of a Ninth Circuit District Court case, Swanson versus United States. It's a resolved issue. That is an 11-foot raise, 11.5-foot raise in the lake level. That is not insignificant. And of course, when you're talking about where the lake is, where the high water line is, it depends on how steep the shore is at that point. If it's a 1-to-1 slope out into the water, then it would be another 22 feet beyond that point. If it's less steep there, you get further and further out. Now, Mr. Russell's report, I believe, if I understood his graphic up there, was that the ordinary high water mark pre-dam was 50 feet further out into the water than it is once the lake level's filled up. So the question becomes, okay, well, what did the viewers who were settling that road, that easement, what did they mean? I find it a hard stretch to believe they meant it was 50 feet higher than the actual lake level when they said at the high lake level. And they included a map that shows that easement, that public right-of-way going right down to the lake. Now, I would assert it's not even a matter of what the viewer meant or didn't mean. It is a matter of law, and a call to a natural monument like a lake trumps distance and bearing calls if they conflict. That is what we call the order of precedence in real estate law. When you're talking about dealing with how to interpret legal descriptions, a call to the lake always trumps a distance and bearing call if they conflict. So while I have a great deal of respect for Mr. Russell, we work together, he's a good surveyor, I do not necessarily agree that a meander point line would trump the call to the lake. So the easement itself, or the public right-of-way, without question in my mind, extends all the way out to where the lake level was in 1909. So if we're talking about, it doesn't matter whether people put private signs on it or somebody polices it or doesn't. The reality is, what is the legal right? What is the public's legal right? The public's legal right right now extends well into the lake at high water mark. It does. Extends, according to, if I looked at the graphic right, 50 feet in. That would be, of course, plenty of room to put a dock. And that brings me to the next point, which is some of the historical information that we found when we were doing the litigation. First of all, I have a USGS map from 1929 that actually shows the high water mark at Camp Bay at that point to be 2,048 feet. But by law, it's 2,051. So it's sort of a moot point. But we also have, it's called Beautiful Bonner. It's a book that's in our local Bonner County Historical Museum. And in that book, there's an article about the steamboats, what one of the gentlemen was talking about earlier. And in it, it says the steamboat Western docked at Camp Bay. In this picture was built in 1910 by the Northern Navigation Company. And then it pictured are the captain and the engineer. So what this shows us is that there was a dock that existed at Camp Bay back then, way back then. We also have a aerial photograph from 1935, which shows a dock at Camp Bay. The reason why this is important is because we know that there were a huge timber trade going on back there. There were mines in that area. The viewers report itself references fishermen. I think this evidence shows that it was the public was accessing that area, not only to put supplies in and out for the settlers that lived there, but also to use it for recreation and other purposes, and simply to travel. And if the public right-of-way ended 50 feet above that, that wouldn't make any sense to why you'd have a dock in that area. And I bring this to the commissioners mostly just so that you have all the evidence that I know, because it's an important decision. And I suggest the decision as to whether or not this is in the public benefit, it's not one where it's just, okay, can we think of a reason why where the public would benefit? Any reason. And if we think of any reason, it's in the public benefit. It's not that. It's a analysis of whether, given all of the factors we have, it is actually the best interest of the public to vacate this public easement. There are other factors. We've heard about trails, we've heard about fishing, we've heard about recreation. The simple fact is that the public right now can drive right into the water at the high water mark and still not be beyond the public right of way. Whether that continues to exist is up to the commissioners. The other point I'd like to make very quickly, just in terms of the public interest, if simply saving money on maintenance were all it took to justify the vacation of a public benefit, I would suggest that you could vacate every public benefit if that's all it took. I mean, every county road at least the county roads that the county maintains cost money. So I would, respectfully submit that that's not a reason in and of itself. There doesn't appear to be an issue with the width of the road anymore. It's 50 feet. The county has already said it's 50 feet. The amount of acreage the county has calculated it is vacating is based on a 50-foot right-of-way. 2.93 acres only works if the right-of-way is 50 feet. That's not in dispute. The last thing I'll say with respect to Mr. Russell's report is he admits that the viewer's report is general in nature. It is not survey accurate. It isn't intended to be. They didn't do it survey accurate. It's just a line. So in the call to the high water mark trumps everything. If you do vacate it, just understand you are vacating a right to the water. Thank you.
It's 3:40 and apparently this commissioner need a bathroom break. We're going to recess now. Back in 5 minutes. Let's see, we ended with, you want to serve? Okay. Yep. It's open. Let's see. For those of you standing, there are some seats available now. And if you want to speak, you have yet, I don't recognize you, please let me know so I can get you in.
Good afternoon, commissioners. My name is Allison Dunbar. I'm a resident of Bonner County. I'm also a real estate attorney in town. And I want to say that while I work with Mr. McLaughlin, Mr. McLaughlin and I came to the same conclusion doing our separate research and separate analysis of this issue. But honestly, the legal issues are so commonplace and so well known in Idaho that as to the property, legal property aspect of this, it's pretty simple. When we're talking about the public access issue to the lake, and we look at the evidence that we have, which is this viewer's report, which is remarkably good evidence considering how old it is. As Mr. McLaughlin noted, calls to landmarks always trump calls to measurements. And that's because it's easy to mess up a measurement, but it's real hard to say that the mountain or the lake were in the wrong place, okay? And so that's in the rules, that's in the set of rules and directions and guidance for how surveyors read legal descriptions. And the viewer's report is the closest thing that really is a legal description we have here. And the footnote calls to the high watermark, okay? Now that overrides the call to the meandering point. You just don't get to pick the meandering point over the high watermark. It's just not how it works. The second issue with the high water mark as to where the high water mark was then versus now, that problem is easily solved when you consider the rule of accretion and accrual. Okay, accretion and accrual makes up for when lake beds, riverbeds change shape. We don't redo all the property boundaries when that happens. We don't go, oops, this little 10-foot spot appeared. The state's gonna deed that to somebody. When that happens, it just extends whatever property it's part of. So as the lakeshore changes, the property that's between the original boundary line and the lakeshore just adds on to the ownership of whoever owns the property. And all calls to the water line change with the water line through that rule. So this call to the high water mark changes when the high water mark changes. I don't mean when the high water mark changes seasonally or in a flood year. I mean when the high water mark legally changes. And the reason that we have a legal definition of what the high water mark is because the state owns the lake bed and they want a stopping point on our right of accrual. So that's the maximum amount of accrual you can get. But everything up to that point relates to that high water mark. If the legal description calls to it, in this case it does. So it doesn't matter legally if the high water mark keeps changing, that point changes with it. So the entire explanation of where the high water mark was now or then is totally irrelevant. It's a disguise for the actual underlying issue. Regardless of the lake access, the development doesn't need this. Development just doesn't need the road. They don't need the road. They can have a development there and everybody can still use the road. Most people live adjacent to a public road. It's not going to hurt these people. As was pointed out, some of these lots have already been deeded. It's very possible to deed a road that's connected to a public road. We all know that. There's this assumption in some of the bullet points that says that this will be good for the lake. I don't see any empirical evidence as to that. I don't see any study to that. I don't see anything in the record that actually says that beyond someone just verbally stating it. If the development wants this road, they should pay for it, just like we all pay for our property. It is a breach of the commissioner's fiduciary duty to the county to give away our assets to companies. That is wild. Even if we hadn't paid to maintain it, which we've been paying to maintain it for years, which is why it is of value, it would just be wild for the county to just give our assets away. I mean, that just doesn't make any sense. So if the county is going to grant the application, which I assume the county is inclined to do, unfortunately, I really ask you to consider, under the statute, you have the right to charge for it. You have the right to charge fair market value. An assessment should be done and you should be charging fair market value because that's our asset and it's just not appropriate to just give it away. It's just poor financial sense and it's not a good way to manage your assets, and you are responsible for managing our assets. The last thing I want to say is this is not in the public interest. It's literally only in the best interest of the applicant and nobody else. So I would really appreciate if the county commissioners could take that into consideration. Thank you.
Allison, I got a question for you.
Yes.
It sounds like you studied this, and I'm intrigued by the rule of accretion and accrual. How do you rectify the 2051 Ninth District Court of Appeals ruling?
Sure. So I rectify, I think it fits really well right in. And the reason that they've made that ruling is because in the olden times, or what in law we call at common law. Yeah, just any time before I was born.
I was actually going to go there, but I thought I don't know.
You could, the landowner could accrue or lose through accretion as much or as little land as the watermark moved, right? And the annual watermark would, just change with the average, and you could lose or gain whatever. And that ruling says we're picking a maximum line and you can get up to it, but you can't go past it because the state owns the lake bed no matter what, which is different than rivers, et cetera. But it plays right into that. And it wouldn't have been necessary for the state to make that ruling. The state wouldn't need the benefit of that ruling if it weren't for the accretion accrual rule, because without that, your property boundary would just stay wherever it is, regardless of the movement of the lake water. So that ruling is based on and necessitated by the accretion accrual rule.
So one more question. Is there a number of parts around the lake that do have land that goes under the water?
Absolutely.
What's the effect on accretion accrual and the 2051 ruling on?
Sure. With regard to the lake, because we have a maximum and because the state has said that's the maximum, that's the line, along our lake bed, for the most part, that rule is null and void unless it's to the benefit of the state. So unless it's going past. In some places we see where there was always a gap and those people do probably have a right to make a claim up to the high water mark. But we see quiet title cases all the time around the edge of the lake because there's a gap in a legal description, but not a gap in legal ownership necessarily.
So then if they own land under the water, a property owner does, and the lake recedes down to the winter pool, which is the pool they picked, do they no longer own that land, or?
No, it's not based on a seasonal change or a flood year change. It's based on an average is how we normally do it. I mean, it's almost moot because of the high watermark ruling that we have. Almost always trumps that in this situation because it's almost always higher than the average watermark. But and so in our county, generally we see it more often with stream beds. For example, on Lightning Creek, there are numerous places where the stream bed is moving over. It's moving east, and we're seeing the western landowner getting more and more property.
However, that property line still doesn't change.
The legal ownership changes, the boundary line in the legal description isn't going to change unless you ask the court to change it for you. But there's still a claim to ownership that exists there.
Because my understanding was, we owned some property on the river at one time, it was pre-dam, and it went clear down to the high water mark of Ponderay River, which is a whole lot different than actually Ponderay Lake. And it was our understanding that we never agreed to the flooding of the property, so we own out to the watermark of Tree Dam.
And we have a similar instance. We used to hay in the bay. It was during the summer, walking down the summer. And when they built the dam, it actually covered our land.
Yeah, the state issued a statute that allowed it to take everything up to the new high water mark with the dam. So that I don't think that impacts this case at hand at all. But I encourage you guys to talk with Bill about it. Bill's, I'm sure, able to answer more questions about it. And
We
I
never
just,
understand what he said.
well, I just want to give you some context to hear what he's saying. Thank you all.
Well, I got you up there, and I don't know, maybe I should be directing this to Bill for our council, but easement versus owned right of way. In code, it says something about if the easement is given up, then it reverts back to both the property on either side. And are you aware of that?
Sure, yes. When an easement is vacated, an easement is, we talk about ownership as a bundle of sticks, and use, enjoyment, occupancy. Easement is just the stick that is use, right? Like you don't own it when you have an easement, but you get to use it. So if the easement disappears, then the underlying landowner gets it back. A public right of way is a little bit more than an easement. It's akin to an easement, certainly the easiest way to understand it, but it isn't just an easement because it garners more under the law. I mean, it has more obligations, particularly because to receive an easement, one doesn't have to accept it, but the county does have to accept public right-of-ways and dedications because the county is responsible for maintaining them after the acceptance. So it's a little, in this case, we're talking about a little bit more than an easement.
It's a little daunting with this many attorneys in a room. You're like, it's like, holy small. You get like 7 different.
I think we revert to circle of death now with the attorneys.
All right, thank you.
Thank you all.
I got one more question for you.
All right.
All right, what we've seen brought before us historically, originally, end of the road would have been actually further out, but that changed as when the dam came. But it was always a thoroughfare to somewhere else in the lake originally. So our right of way and easement actually would have went to the end of the dock, more or less. So now where are we at?
I believe that the county has a
The
public.
dock's gone.
Sure. I believe that the county and the public has a right of way up to the ordinary high water mark as defined by the state and the court. You don't get to have a dock beyond that because that belongs to the state. I mean, I guess the county could apply for a dock permit or, like we all can, but it goes up to the high water mark. The right of way goes up to the high water mark, whether or not it's paved or graveled. I mean, that isn't really relevant. It's good evidence of use, but I think we have the right to use all the way up to the water.
Regardless of the lake level.
But up to the ordinary high water mark defined by
Ordinary high
statute.
watermark, seasonal high water mark.
No problem.
It goes to the 2050. Yeah.
Yes. Yes.
Okay, thank you.
Thanks, guys.
Yes.
Okay, make sure you identify your name for record.
My name is Jeff Beeman. I've lived in the county for about 31 years. I used to park my pontoon boat when it was stormy out on the lake. I'd beach it on that gravel beach. That gravel beach is, if anybody's been on the lake and boated around it a bit, there's not a lot of safe places to pull off. And that gravel beach saved me more than once. So it's important to me that I maintain that access. I also like to, it's also been on my tour of when relatives come, I go to show them the lake. I drive down Camp Bay Road and we can, go right up to the beach there and look out at the monarchs in the distance. So it's a pretty, to me, it's valuable. And I think apparently to a lot of people here, it sounds like most people are in agreement with that this is an important asset to us in this community. And so I would hate to see the county commissioners give that away. I don't see a compelling argument being made to give it away to this developer. And if nothing else, I guess I've heard through this meeting here is that there's some unanswered issues, I think, and some questions. And I even hear that in the questions asked by the county commissioners. I sense a little bit of uncertainty there on treading forward on this thing. So I hope that at this juncture, the county commissioners would be opposed to vacating the road, would be the number one thing. And if you can't go that far today, at least delay the vote and allow more information to be obtained to help you make a better decision on this. Thank you.
Hey, you heard these folks stand against the wall. Let's start over here and work our way back. Well, you can go if you want. I don't care.
I'll be short. My name's Nick Royale, and I'm a Bonner County resident. I don't live down there in the area, but I hike it frequently. And I'm strongly opposed to vacating the road. Everybody before me has said so much that the only thing I'd really like to add is, assuming that there is a public lake access, aside from everything else, to me, if that exists, there is no argument to be made at all that this is in the public interest. And as we have heard tonight, the legal issue is not as simple and straightforward as it was put forth at the beginning of the meeting. There's at best a question as to whether it exists or not. So I am opposed.
No, go ahead.
Thank you, Mr. Chairman and members of the commission. My name is Brad Smith. I'm a resident of Sandpoint and also representative of the Idaho Conservation League. I want to thank you for the opportunity to speak today on this issue. I grew up in Coeur d'Alene, and my family used to spend a lot of time on Lake Coeur d'Alene, and I watched as that whole lake got developed and the access and the shoreline was taken away, and we're never going to get it back. And it saddens me to see that happening here. So it's hard to imagine why vacating this right of way would be in the public interest after observing what's happened to the people who used to use and enjoy Lake Coeur d'Alene, but have a hard time doing anymore because all the access has been scooped up by people with money and privilege. So I hope that you, if you have the discretion to do so, will reject this proposal. Mr. Bradshaw brought up a point that I think is relevant here too in your consideration, and that is, where is the terminus point? It's hard for me to imagine that back in 1909, the people that laid out this road knew that Albany Falls Dam was going to be built and that they should terminate that road right above the artificial high water mark that we have today. I mean, people do what people do. They go down to the water. So that road went down to the water. There's no doubt about it. And I ask you to protect that access and that right of way because it's in the public interest. And also with regard to the water quality issues that have been raised, whatever sediment that road generates is negligible compared to the pollution that will be caused by the septic systems, people fertilizing their lawns. Next thing there will be algae blooms out there in Camp Bay and people won't even be able to swim in it. So please deny this.
Hi, my name is Andrew Moore. I appreciate the opportunity to speak. I oppose the vacation of Camp Bay Road purely based on the fact that it is not in the public's best interest. And I urge the commissioners to act on the interest of the public. And I think we have a good case of that here today. I grew up in Garfield Bay and I lived out in Camp Bay for a couple of years, and it's just an absolute dream. The intrinsic value that one gets from driving out to the end of that road and parking for even 5 minutes to, to watch the moon come up over Scotchman's far outweighs any multi-million-dollar development. Thank you.
My name is Rod Barkley, and I turned in my presentation to the Board of Planning and Zoning, and also you also have mine up there. And so I'm not going to include everything in that, but I'm opposed to the vacation as well. And I've lived in the county for I've lived in North Idaho 35 years. I taught school up in Bonners Ferry. My grandmother rode the ferry from Bonners Ferry up to Kootenai Lake back in those days, back in the early days. And so my heart is here, is in this valley, and access is everything. And Camp Bay is one of the most beautiful sites on this lake. I know that's arguable, but it is one of them. And we don't want to lose this access. This means a lot to me. And I was a surveyor, and I understand, there can be errors in that, but the intent of that survey was to have a road from the lake. And that's what it was originally designed for. And I would hope, and I'm trusting you, that you will find a way of codifying that 50 feet. That belongs to us, the people here. And people are moving here because of why we all live here. This quality of life is really important to us. It's why we're here. It's why I'm back here. My parents, it's funny that my original half of the family left and went to Canada in 1915 or 1916, I believe it was, because it was getting too crowded in Fort Hill. And they went to Central British Columbia. But the other half of the family that I'm from have stayed here, and I've made my living here. And that's all I want to say is that please make the right decision. Please change your mind. Thank you. I live on Ontario Street, by the way.
Oh, good. They don't care where you live. I mean, I know sometimes cities, you have to tell them, yeah. Sir? Nope. Asia still on laptop? Nope. Guy with mask on and on here? Nope. Hey, hang on just a second. I'll work my way around back to you. Sorry.
He was like on the wall. So.
Oh, you were on the wall before?
No. Fourth guy in this row right here. I was the wall guy.
We got a taker.
Hello, I'm Russ Edwards from Camp Bay. I've lived on Camp Bay for 30 years. Russ Edwards.
Sorry.
And I'm for the vacation. I think it's a good quality project that's going on out there. I'd like to address the Randy Green issue. You do know that his 3 kids sued his parents to death. They tried to have him committed or claimed incompetent for 3 different lawsuits.
That has nothing to do with
it. Has nothing to do with this, but you bragged on Randy. You bragged on Randy, and he's supposed to be this credible witness that said Camp Bay had a public usage. So I wouldn't trust Randy for nothing. I knew Ralph and Jeannie really well. They were nice people. So anyhow, as far as people using the bay, I don't know if it's the worst thing in the world, but I do know this. What I see in the usage of the bay is people pull down to the turnaround, and probably 50% of the time I'm cleaning up beer cans the next morning when I go to work. So that's what it's being used for at this point in time. So, I mean, I've been there for 30 years and I have not seen it used for public usage ever. So take from it what you will. I mean, I just don't see the thing. Let me change this a little bit. I didn't come as prepared as I see a lot of people do. But the one thing, asphalting Camp Bay Road is a major bonus. I know that Sharon Frazier's been driving that road as long as Janet and I have. And we used to have to mud bog in 30 years ago. And so I'm really for the improvement on the roads. And if the developers are willing to pay half the price of the road, I think it's an incredible thing. So I know that nobody here agrees with me, but, well, you're right. But I mean, how many of you bet?
He has listened to all your.
Yeah, for a long time.
and it's been repetitive. But anyhow, so I see a major benefit for the road to be asphalted down to the turnaround. The gate, I'm not going to argue about that one. I know Sharon has walked the road for a lot of years with her dogs. That I agree with. I haven't seen any other faces, but that's okay. I do drive the road usually 3 to 4 times a day, and there's people in here that are heavily opposed that are up the road, and I've never even seen them on the road. I think they mostly sit behind their laptops and I don't know what they do, look for things like this to fight because they don't have anything else to do. So just my opinion.
Okay, thank you. Go ahead.
So my name's Craig Gill. I was at the last meeting. There was a lot fewer people here. Started coming to Camp Bay in 1970 with my grandfather and never saw any people on the beach. 1980, never saw any people. 1990, 2000, 2010. Now suddenly a bunch of people want public access. So I guess you can tell I'm for the approving vacating the road. I do have an easement across green property, so that will be nice to have it paved. The road's been moved already, and I don't have any concerns with getting to my property, my home. Camp Bay is very, very dear to my heart. I get how everybody feels, you know, Idaho's changing. I hate to see it change, but we can't stop that. So is it okay if I read a letter from my neighbor?
Sure.
Okay. So this is from Michelle Anderson. She was Michelle Donahue when she, her parents were next to the rented cabin my grandparents had on Camp Bay on the green property. And Michelle says, I've lived summers at Camp Bay or right outside of the bay to the north for over 55 years. The Green's daughter, Sheila, and I were companions for 20 years or more, and I knew Jean when the old homestead house was still safe enough to bake cookies in. At the end of the road where Camp Bay touched the shore, there was a huge swamp. My brother and Sheila Green caught lizards and frogs there. Nobody came there to swim or recreate. Over the years, it became a bit drier and the rocks took over where the weeds were, but the beachfront appeal is a relatively modern phenomenon in that part of the bay. In fact, I have never seen anyone I don't know taking a dip at the end of the bay. I also am quite sure that if anyone tried to have a party there, Jean and Ralph would have asked them to leave. They were quite strict about who was present on their property and what kind of activities were happening there. The idea that there were hordes of beachcombers having bonfires is absurd. The photo has more persons on that stretch of frontage than I have seen there in my entire life. And that was a get together a few weeks ago that I think a lot of people here attended. So I had a question for the surveyor, which was when they put the road in, did the green, that was green property, right? That the road went over from the part that we're talking about that's being vacated. That was.
I don't know if they want me to answer. You know, go ahead. The road vacation are different than thing here, so go ahead and answer.
Okay. So the road was put on green property, right? When it first went in.
That would be,
the road.
It was a green, predecessor. But yes.
Right. Okay. So, well, it was the Van Shrevendykes.
Van
It was Kate Van Shrevendike. They homesteaded on that property, right? Okay. So did the county pay them for that land or did they just give it to them?
In the record, it indicates that there was no damages. They estimated the cost for the road at $600. I don't find in the record where they actually paid them for that. Or I would gather from that statement that the county contributed up to or about $600 to construct the road.
Okay, but the value of the land was given.
No, the land was donated.
The land was donated. So now isn't it kind of being given back to the property owners that? It started out as green property and it's going to revert back to green property. Don't you guys all own property? Don't you own property? Would you want someone telling you what to do with your property? I don't want someone telling me what to do with my property.
Try not to.
All right. So I'm opposed, I'm in favor, and thank you.
Okay. Who's next over there that wants to speak?
Hello, my name is Scott Enzen. This is going to be a little awkward. The letter that Craig just read of Donahue, we bought that place in 2006 down in Camp Bay. So we had one of the cabins that was on the lease there. And I work from home and my wife is retired. So until 2020, when we lost our lease and had to move out, 14 years, pretty much full-time residents. We do have another place up with Rapid Lightning, so we split some time, but we spent a lot of time there. Working from home and going out after having a beer on the deck, sitting on a campfire. The amount of people who come down there and use that, turn around and just enjoy that view is astounding. They're trying to downplay that, but there is a ton of people who use that. It is amazing. Not knowing that you ever had lake access, that's a different game changer. If that is true, and it sure sounds like it from what everyone's been saying here, that is just, it's what do I call it? It's invaluable, thank you. So I oppose litigation and I hope you do the right thing.
I'm calling you next. I noticed. No, you're there. You're off.
I'm Jason Yan, residents of Sandpoint, property owner in Sagal. I oppose this, and the technicality of the high water mark is pretty insane to me. I just could not imagine a farmer, shuffling off cattle back in the day, and then a guy coming out going, "Hey, that's high water mark. You can't get your cattle up here." So I look at things a little bit simpler. Seems like a no-brainer to me. So that's it. Thanks.
Okay, moving back over here. Who's next? No, is that what you serve with the other things? No. Nope. Ask, you want to talk about snowmobile and your bikes?
I don't know why, but.
No, you gotta go front so we can all see you. Oh, and you have to make sure you say your name correct.
Okay. And you have to order pizza for everybody.
Park Gunner, Sagal, Idaho. And I don't know why, but I was told to bring a 50-gallon drum of tar and several boxes of feathers. So I've got them outside here. I don't know what we're gonna do with them, but anyway, I got them. So that's, oh, by the way, I opposed this, so.
That's why we don't let it stuff out.
Don't forget to stay there.
My name's John Hobday. I've been a real estate broker here for 30 years. I own Alpine Realty. Was with Century 21 5 years before that. A lot of it's been covered. I just want to read one thing. What is a prescriptive easement? Because this is what it boils down to in my mind. Prescriptive easements have been recognized in Idaho for decades. A person claiming a prescriptive easement must prove by clear and convincing evidence that their use of the property in question was, number one, open and notorious. Number two, continuous and uninterrupted. Number three, adverse and under a claim of right. Number four, with the actual or imputed knowledge of the owner or of the owner of the subservient tenement. Number five, for the statutory period. Let me give a number for the statute. Frequently, a prescriptive easement claim is defeated by evidence that the easement was used based on permission of the property owner. The time period for demonstrating the prescriptive easement is now quite long, 20 years. Prior to 2006, the prescriptive period was 5 years. All of the above elements must be proven, which means to summarize, the use has to be open, has to be continuous, adverse, and without permission of the rule which apply in certain circumstances that we have not explained here for the sake of brevity in providing the overview. And basically, it's a prescriptive easement. People have been using that for, I used it 49 years ago. My wife and I went on a date there. This very property. Okay, we've been married for 48 years now. My grandchildren want to use this property. Vote it down.
Thanks, Dan. Appreciate it. Yeah.
Make sure you identify yourself for the record.
Try not to fall like that one here. Those of you that don't know me may not understand, but I was born with what they call spinal cerebellar ataxia 18, which causes me to not be able to feel some of my extremities, and I don't walk very well one, especially in front of a crowd like this. So I'm the director of Bonner County Road and Bridge. This was brought to my attention by Mr. Clark quite a while ago. I want to say it was like he was talking. It was prior to December, I know that we actually talked about it. In looking into this, Bonner County Road and Bridge we typically oppose anything that has to do with actual vacation of the public right of way to a lake. So in that, sorry, I'm a little nervous here. I hope you're happy. It is my job. I got to do it. So anyway, in that, Mr. Arn, I don't know if he was in here. Oh, he's out here with me.
I got thrown out.
He got thrown out. So anyhow, he had called me about some no trespassing signs that were down at the lake. He started making statements about that being a public right of way, so on and so forth, that they actually had an easement to the lake. I had seen it in the paper, so I started looking into it a little more. I was never aware of that. When me and Matt started looking into this, the viewers reports that we seen showed it terminated at Camp Bay. It never actually stated that it went to the high water line. So going through that, I actually found some documents that Toby McLaughlin had actually had from a lawsuit that he was dealing with. It is stated in a, what do they call that, the surveyor's book of records that the county had. It's an old book, big, like the, we started looking at it and it had a termination point or turning point, which I don't think has been actually done legally to see what that actually stands for, but it sounds like termination point would probably be the proper word for it, but being at the high water line. With that, Bonner County Road and Bridge did not change our views for the vacation of the road, especially because the ordinary high water mark, which was established obviously from Swanson versus the United States, stated it at 2051. However, I wasn't certain, and I'm still not certain today, on if the actual termination point would have been at the flood line, the high water line. And the reason I say that is I am a road builder, and building a road underwater doesn't make sense for the public. I mean, we would build it above the high water mark. There would be flooding, correct? So when I look at that, that's where our road would have been, in my opinion. So based off of that information, there is what I'm going off of. I don't know M3 other than the dealings I've been having with them, nor did I know the Green family.
However, I was the foreman in that district and I maintained those roads for the last 12 years. I was the foreman and we never had any rights to the lake that I knew, that I was aware of. So with that, when people come up to us and they ask us about an LFI, which is actually in our road standards, section 14.2D, it actually states in there that if people want to upgrade their roads, they can come talk to the director or the county commissioners and get that process started by donating money to actually bring that road up to what they're wanting to do with it. At that point, the county can either say no or they can say yes to it. When I look at, well, I shouldn't say when I look at, when I'm hearing a lot of comments in here and out on Facebook, is the price that the county was putting up against that road within 3. When we look at an LFI, people actually, they ask us what we're contributing at that point. The Bonner County contributes, we contribute our labor and our man hours. So to put a price on that, I sit down and I look at our equipment that we're using. And I look at the private sector and what they typically would charge for a contractor to come in and do that, because we own our own equipment. So I start putting hourly rates to it and figure out the gravel pits, where we're going to be hauling this rock from, how many hours we're going to have in the hauling the rock, get everything there to get it set up. And that is our contribution. And in doing so, that's where that $830,000 comes from. Is our actual time that we're using on this. The rock, the asphalt, all of that is paid for by M3, not us. There is a section in there for $77,000 that the county contributes, and that was specifically for, there's a big rock about halfway out that road, 3/4 of the way out it, and that was for blasting and along there, and some culverts that we need to repair in that area. That's what that $77,000 was for. That's what brought it up to the $803,000. I just want people to understand that we're not just out forking $830,000 out to M3 or anything like that. We're actually taking into account what it would cost for a contractor with our equipment that we already own, because it just wouldn't be right to not do that. We got to have some kind of a cost put towards it. So with that, the paving of Camp Bay Road is a huge deal in my book. I've worked for the county for 27 years. I should say going on 27 years. I hired on 95. And I've seen these roads go from mud to people walking into their places to pave. Now, if you walk up or drive up, I would say I wouldn't walk up it, but Pack River was a mud hole from one end to the other. You couldn't get up that thing in the spring if you tried. I mean, they at one point, and I think it was in 96 and 7. Yes, I'm getting that old because I've been here that long, but they had the National Guard in here actually helping people get out of their places. So to see these county roads go from that state to asphalt is a big deal for me. And I have a lot of value in that. I mean, I've always loved my job working for the county, and I like seeing the changes that we've made to make this a better place. When I look at the vacation of this road, I mean, that's up to the commissioners. That's not up to me on if this gets vacated. I've heard some folks in here talking about how pretty that access is down there. If I take myself out of being the director of the road department and staying here as a private citizen, it is the prettiest place on this lake. And I've got probably 200 pictures of the sun coming up from plowing the snow and everything else out there in the morning, and it's absolutely beautiful. To not be able to see that would be a shame. It would be nice to be able to still go down and actually see that. when I look at actually sitting back and thinking on a taxpayer's perspective of actually maintaining that road, when we look at asphalt, we like to have a 22-foot wide road with our asphalt when we're going down it. When you get to that last 2,500 feet that we've been talking about the vacation on, it's not a 22-foot wide road, and it has a steep drop off into the creek that goes along. So Bonner County, on numerous occasions in the spring, have been out there rock armoring out. We've put many culverts in there trying to protect that edge of that road from that thing sloughing off. And it's a nightmare for us to maintain. We've been maintaining it. We've been doing a good job at it. So, I mean, it isn't like we haven't been doing it. We have been doing it. But to vacate that portion and put that on M3 to pave, in my opinion, was a good deal because it didn't put that to Bonner County. There's a lot of work that has to go in there to do that. So on that side of it, with my actual professional side of it, then I would support the vacation. However, on my personal side of it, I've been trying to leave this out. I probably wouldn't. Therefore, I mean, that's up to the commissioners. Oh, have you guys got questions for me?
Well, I just let him make the decision since he's.
I should have decided to let you make this.
I don't know if I want to make that decision for you people.
How do you live with tread marks? That's like.
Right.
No, I
So-
have any questions.
No, thanks, Jason.
There is
All
two
right.
sides to it. Yeah. Sides to it for sure.
Yeah, I just want to make sure you had a chance to weigh in.
Should do you guys have any questions for me? I don't mind taking that if you have any.
Why can't they offer to help pay for it like they are, but not give up that last bit of the road? Like, I understand they want to pay road, they want to pay road, so if they want to pay road, why can't they pay for it?
I have spoke with M3 about that exactly. And from what my understanding is regardless of this vacation, they're still willing to move forward with that project of asphalt. So, kudos to M3, you know, on what they're talking about.
People that have said they want this, if they want to pay road, who doesn't want to pay road?
I want to pay for it.
And have somebody else to pay for it. We can't pay for
Alan,
it.
you started.
I did start that.
That's okay. That's not the way it's done.
Thank you.
Follow procedure.
Thanks, Jason.
Yep.
Okay, is there anyone that hasn't had an opportunity to speak who would like to speak?
Oh, yeah.
You didn't speak already? Okay, go ahead. Yeah, we have some people online that are waiting to speak as well, so.
Teresa Stevens, I live in Sandpoint, been here about 52 years. I love this place. I love the way it was. I love to be able to get on the lake. There are fewer places to do that now. The Travers family has probably 75, my mom has 75 grandkids here. They all want to get on the lake. I just think as our kids get older and our grandkids get older, there are going to be fewer and fewer places, and we have to work as a community to protect those places for the future generations. It's not going to go back. It's never going to come back. We've got to say, slow this down and keep this for everybody, not just for people who come here. We love you all, but we can share. Can we please all have access to this lake in one way or another? And it's not just to get to it, but to get in it, to get our kayaks in it and our feet in it and touch it and enjoy it like the Indians did. 1909 was a big year in this community. It made a huge difference. And I want 2022 to make a big difference for the better for Bonner County. And I'm not going to cry, I'm just nervous.
Yes, people online want to see. Why don't you go ahead and light them up one by one there if you would.
Sam, before we go to them, I think it's a good idea to make sure no one's in the hall. I just want to avoid any kind of process issues.
Is there anybody, somebody, Jason, somebody go out there and see if there's anybody else that wants to speak. There we go, we can have our. Just keep going. Let's go check the parking lot. Dude, okay. Go out there. You have, are they coming in? Nobody wants to speak? Yes, I didn't hear you say yes, Mark. There were people out there. Okay, good. Okay, now let's go online. Go ahead, Dave.
So if you're online, raise your hand. We'll go down the list one by one. Go ahead, Susan.
Hi, can you hear me? Hello, can you hear me?
Hear ya.
Okay, great. Hi, everybody. My name is Susan Bowman. I live in the Sully Valley. And the first time I had been to Camp Bay was when I attended a barbecue with about 100, 150 people. And it is really the most beautiful place that I have been to in Bonner County. I do love the Sully Valley though, but I'm coming here to support all of the county. And I think that you just really have one test here, commissioners, and that is, according to Title 40 of the Idaho statute, is that you can vacate this road where doing so is in the public interest. So that's really the test that you are faced with today. And you know, hopefully you're not going to look at the public interest as, you know, a unicorn or something like that. Hopefully you're going to see it for what it is, which is that it means that there is an interest shared by the community, by the citizens. That's what the public interest is. Clearly, this is cherished. This area is cherished. It's not even just loved, it is cherished. And it is important to everybody. That is the public interest. That is what it's all about. And so you as commissioners have a very important decision today to protect and hold sacred the public interest. And you have a tough job. I really don't, I know that that has got to be hard sitting in those seats today, but you're faced with the public right now telling you what their interest is. That's really the bottom line here. So I hope you make the right decision today. And you haven't always, but you have a chance to do that today. So we're all pulling for you and we're hoping you're going to make the right decision. Thank you.
Next. Nancy? Can you hear us?
You're muted on your end, Nancy.
Nancy, you need to unmute from your end if you can hear us.
Okay, can you hear me now?
Kind of.
Can you hear me now? I'm sorry, can you hear me? Okay. Hi, I'm Dr. Nancy Gillum. I live in Sagal and I live near Camp Bay. I appreciate everyone's participating in this process. My point I want to make as someone who lives near Camp Bay is that I understand you're trying to prove that closing the road is in the public interest. Well, I strongly disagree. I hike, I ride my bike, I have a horse, and I personally don't want to see the roads paved. They're not all of us that think that that's a great idea. It's going to speed up the traffic. It's going to mean more wildlife being killed. So I'm from Virginia, where parts of the state have said we don't want our roads paved because we use them recreationally. So I don't know if you've surveyed all of us to find out if paving a road is what we want. That's my first point. My second point is, if that's the justification that the taxpayer is going to save money because of the road improvements, I think it's going to be offset by the fact that when these $1 million homes go into Camp Bay, my property taxes are again going to go up, and that's going to offset anything that I might save as a taxpayer for a paved road that I do not want. Thank you for listening.
Megan?
Megan?
Yes, hello. Can you hear me?
Yes.
My name is Megan Green. I have been going up to Camp Bay since I was in my mom's belly. My grandmother, Jean Green, was a huge conservationist. She wanted that land preserved for everyone. She actually made it in her will that the land was supposed to go to the Boy Scouts, the Girl Scouts, and the Gamblin Lake Cemetery if my uncle did not place it in a conservation easement within a year after she passed. That never happened. So I don't even think M3 rightfully owns that land to begin with. It just really strikes me that someone could get up there and talk about knowing my grandmother and speak ill of my father and know that my grandmother never wanted that land developed. My uncle conned her into giving it to him, thinking that he was the only one who was going to preserve it. And now that he's developing it, I'm sure that if she could see this, she would just cry. It pains me to see the neighbors getting their access taken away. It pains me that I can't be up there and living on my family property. And instead I have to be a nurse on the front lines of the pandemic. I just really hope that you'll do what our democracy is set up to do, which is to represent the will of the people. And it seems overwhelmingly that the will of the people is to preserve it and to prevent the development. And that's exactly what my grandmother wanted. She didn't want her land logged. She didn't want it sold to rich developers that were out of town. And I didn't know Steve Klatt from Adam until he came in and wanted to subdivide the land and make a bunch of money off of it. And I'm just speaking on behalf of my grandmother and my great grandparents. And I don't think that the woman who gave Pearl Island to the state of Idaho would want a gate put up and her land developed. Thank you.
A Brown, what does the A stand for?
Adeliza.
Go ahead, Lisa.
It's Adelizza. And my husband, Jesse, is also here. We are actually Jesse Brown. We actually live on Camp Bay, and we purchased our house about 5 years ago. And we've been coming down to the end of the lake by car, by bike. We've walked our dogs. We absolutely love that area. And, we didn't find out until the Arns, our neighbors, actually had mentioned and brought it up to us. And we had a meeting at the Livermore Lake community over here about that ability for us to actually possibly be allowed to go into that beach. We were prevented from going there because of the big no trespassing signs. Mm-hmm. We are concerned about the paving of the road causing our road to be more highly trafficked because my kids play outside and they're on their bikes. We have dogs and we have signs all along here with our neighbors that, ask people to slow down. But we were told that if they reassessed it, that the speed would probably be increased if that people actually go faster. And so that's a major concern for us to have it paved. I personally would like to have it paved. I think it's great, less dust. And
hi, I'm Jesse. I'm a mail carrier here in Sagal. So I travel all throughout Sagal. I travel Camp Bay Road 6 days a week, and I do see a lot of people driving down that or walking down that road. I'm down there, like I said, almost every day, all the way down to the end. I don't support the road being paved, despite driving on the road every single day. I'd like to be able to walk down there and access the lake instead of just stopping when I'm in my mail car and looking at it, or when we walk down there. And traveling around Sagal on all the mail routes here along the lakeshore, I see very, very limited lake access all throughout Sagal. Every beach I come to is private property owned by a community or by an individual. And I don't want to see that happen to this one. It's one of the very few left.
Yeah, we're not so concerned about the paving, but we are concerned about the gating. It just seems like that piece of beauty on our street alone is going to be taken away from us, and you know, that's
being able to go down there was one of the reasons I wanted to live on this.
one of the reasons why we bought our house. We want us is the beauty and the nature of being, you know, seeing and enjoying it, hiking the trails that we have here, kayaking on our little lake, and we would like to be able to kayak off of that lake if we could. When we were down there at the barbecue, the kids just had the best time on the beach. So that was the first time we were able to even step on the beach, because many people told us, oh, you're not allowed on there, because that's, you know, they've got the no trespassing signs. So it is a value for us to be able to enjoy what's at the end of our road. One of the biggest reasons why we're here. And my husband's family's lived out here. And
I was born here, and I have seen most of the lake access go away, and I don't want to see this.
So we are opposed to this vacation.
Next, George.
George Garrig, I want to go on record as strongly opposed to the vacation of the road. I think there's been plenty of testimony showing that it in no way could be construed as being in the public interest. I'm wondering why, given the overwhelming evidence that it's not in the public interest, why it even came before the Planning and Zoning Committee, and given the fact that you were remonstrated in the lawsuit, it's kind of unimaginable to me would vote to vacate it. Thank you.
Okay, Kathy. I can't read. Thank you. Thank you.
Hello, can you hear me?
Yes, go ahead.
My name is Kathy LaFleur. I am the granddaughter of John and Kate Van Scravendijk, the daughter of Jean Green. This is a very emotional situation for me. My mother wanted more than anything for that property to be preserved as it was. She worked to have a conservation easement on 280 acres. She wanted the people that had leases on the lake maintained. We were all supportive of her. She was slipping badly into dementia. I am a mental health therapist. She was very open with me. In 2009, my brother said he would move up there to be close to them. He was the oldest, 65 years old. We knew he could get Medicare, so insurance for him would not be an issue. Unbeknownst to us, he kept delaying and delaying and delaying. Finally, we were becoming so concerned about my mother's safety that we filed a guardianship for her. It was meant to have someone to come in and give her medications and to take her blood pressure. It was not meant to be anything cruel. Unfortunately, she suffered terrible falls and ended up taken out of her home, screaming in pain, never to return. Now, I don't know what is more cruel, trying to be children, helping your parents, and knowing they're vulnerable to exploitation. And during that time period, my brother convinced them that he was the only child that would do what they wanted, even though about every 10 years, we had a big go around with them about wanting it to develop it, and they were opposed, and they'd have a falling out. Mr. Clapp came along and he was to get us all a lakefront lot. He would use his connections with the planning department to do that. Jim was the only one that managed to get one. I am sorry that I have to go through this horrific family history, but Jim cashed out for about $7 million. We have a special needs younger sister that got $10,000. Jim brought in his stepsons and brother-in-law. Every time we tried to bring up a conservation easement in family shareholder meetings, they outvoted us. We had 2 minutes to talk, 2 minutes to make a statement, and nothing acted upon. We have been exiled from our own family. I am significantly opposed to the vacation of the road. We don't own it anymore. Green Enterprises should not be on the hook for $800,000. We don't have any money. And M3 didn't have enough money to pay us. They have enough money to build multi-million-dollar mansions, but for some reason, they don't even have the money to pay us fully for buying it. So why would the commissioners even entertain entering into something with a company that no longer even exists? It ended June 29th, 2021. Why is Green Enterprises' name on the petition? And knowing that M3 doesn't have enough money to pay us, we have to take out 0% loans and loan them money for the next 4 years. I'm just appalled at the whole scenario of what's happened. My mother felt that land was sacred. We've been in the family, was in the family for 120 years. She did so much giving Pearl Island to the citizens of Idaho. She really, really wanted to honor and let the people that live there locally, not multimillionaires, enjoy the lake. Please honor the Homestead family's wishes. Don't turn this over to people that are multimillionaires that are going to block people that are locals there from enjoying the lake. Thank you.
Okay, next person, Sherry. Sherry, can you hear us?
Yeah, this is Sherry DeRozier. Can you hear me? Can you hear me?
I hear you.
Okay. Yeah, I think it's clear based on everyone's testimony that it is definitely not in the best interest of Bonner County to abandon Camp Bay Road for multiple reasons. I think common sense speaks for itself when you look at where the road ends in the history, but obviously the developer paid a couple of smooth talking suits to come and try to convince you otherwise. But the community, I think, proves that it's quite clear that there is legal access to Camp Bay via the end of Camp Bay Road. In addition to that, I think it's appalling that you were willing to pay $800,000. You talk about the benefit of vacating the road and how much money that's going to save us. And then you go and offer to pay $800,000 of my tax dollars and everybody in this room in order to pave the road for the developer. I think you've heard from the people that live there that they do not want that. I will tell you, I've been here for 5 generations, and since the late 1800s. I lived here before. There was the first gated community in Bonner County. And it's really sickening, the gated communities that are popping up and what they have done to our county, quite honestly. I lived here before. I live on Sully Road, and I lived here before Sully Road was paved. I used to be able to ride my horse, my bike, a walk on Sully Road, as did all of my neighbors. And we could all be friends because you'd wave and talk to people as you could go up and down the road. That exists no longer. Once Sully Road was paved, we lost all opportunity to be able to walk or ride horses or bikes down Sully Road because people just go too fast. Our speed limit went from 35 miles per hour to 45 miles per hour. So I just support everybody that lives in the Camp Bay area on Camp Bay Road, and that has spoke today in opposition to vacating Camp Bay Road. And I just ask you to look around and look at these people that have come today, that have come out in a huge mass to speak in opposition, and just listen to our hearts that we want you to start doing what is right for this community and listen to us. You have absolutely refused to listen to us, and you have been making poor choices for the people of Bonner County in favor of developers. And it's frustrating, and I'm sorry, I yelled at you a week ago, and here I am starting to get heated up again. So I'm going to stop there because I don't want to do that. And I just please ask you to not vacate Camp Bay Road.
Before you leave, I don't know if you listened earlier when Jason talked about it. We're not spending $800 and whatever $1,000 to pay for it. Yes.
Excuse me, I have right here in my hands, and you can't see it because I don't have the video on, but I have the memorandum of agreement signed by you, Dan McDonald, to the tune of $802,733,000.89. So don't tell me that you didn't offer to pave it.
I want to read it. There's a
Still
portion that-
coming out of
I would be happy to share it with anybody who wants. My email address is sanderson208@gmail.com.
So much for being called. Okay. Are you done, Sherry?
Thank you.
Yes, I'm done.
Okay, let's go to Jonah. Jonah, can you hear us?
Yes, thank you. I had to unmute myself. I'm against giving away any public property. I feel like if you're vacating the road, obviously that means it's public. I'm kind of confused. All these people said they had public access to the water. Are you calling them all liars if you decide to go against that and vacate the road? Because they're saying they've had access, correct? So all those people have had access, and by claiming that maybe they haven't had access, and I love the looks you guys give to each other when I'm talking. It's very frustrating. The 830,000, I also saw that. Thank you, Steve. Nice wave. Dan McDonald on Facebook, which is a public forum, actually said what's maddening is that you actually believe the county spending $880,000 to pave the road, LOL. Once again, you failed to research the truth and the facts and instead allowed yourself to listen to others. I won't name, but the problem is there is a form. It does say that you guys are helping pave that road, and it was after the vacation, which is what I was communicating. I guess I'm just frustrated, and all I want to say is claiming this will save the public money or any other nonsensical excuse to vacate the road will not fly in the face of the public's involvement. And we are telling you, our elected officials, that we don't accept any of your excuses for vacating it. And that's good. Thank you.
Thanks, Jonah. So you have the actual project breakdown, and Jonah and Sherry. You've already heard that.
It still costs the town.
Okay, let's move along. Dave Bowman.
Okay, you hear me okay? Do you hear me?
Yes.
Okay, it's really helpful if you answer that question, but I know people are here to serve you, not the other way around, obviously. So look, here's the deal, guys. Yeah, you can shake your head all you want, Jeff.
Okay.
No way. I'm talking now. There's no way that this is in the public interest to give away the public road. I know you guys love to give away public property. That's just one more case of it. But it is absolutely, there is no way this is in public interest. It is in the interest of developers. And it's clearly, the way you guys vote, it's like your own private club that you want to give this stuff away. Listen to the people in the room. Your job is to determine if this is in the public interest or it is not. You got a whole room full of people, would have been doubled in size if you didn't do this in the middle of a workday. 99%. don't want this to happen. That's the public interest. And on top of that, you throw in 830 grand. And then on top of that, yeah, go ahead and shake your head, Dan. And then you show visible disrespect to my wife while she's talking, or anybody else who doesn't agree with you. You know, y'all should just grow up, have a little decorum that matches the position that you're sitting in, which isn't going to be too much longer. That's all I got.
Charlotte also.
Who's the next one? Moose Trail 1117, can you hear us?
Yes, can you hear me?
Can you identify your name for the record?
Marjorie
Marjorie what?
Klein.
Okay, thank you. Thanks, Marjorie. Go ahead.
All I wanted to say was that my husband and I both met with Jeannie and Green in or around 2009 and spent a lovely several hours visiting them. And in our discussions, Jeannie Green was adamant that they wanted the property to be preserved as forestry for the generations to come, as it had been in her family for many years. So I just wanted to lend my support to the Green family children and to those of us that do not want Camp Bay Road vacated. It is something that we have visited many times in the past with our children. No, we have not gone swimming there, but it is lovely to go down there and just walk around the beach a little bit, maybe sit and park for a while, watch the sunset, things like that. So it was definitely something that Jeannie and Ralph Green discussed with us about how they wanted the property preserved. They did not foresee any of this that has taken place over the last several years with the one son that has taken control of everything. So those are my comments, and I ask you not to vacate the land. And I also ask that if there is to be the development that's occurring down there, let the developer use some of their profits and proceeds to pay for the county road to be paved in its entirety if they're the ones that want it, because the rest of us don't need it. The land that you guys have talked about vacating, according to the map, and I may be incorrect on this, but according to the map, that is listed as lot 1, and it's listed at like $2 million. Okay, so if it's worth $2 million for the developer to sell, why would it not be worth $2 million for our county to keep? That is all I have to say. Thank you for listening.
Randy Green, you're up. Please state your name for the record. You know I just did.
Hello, yes, this is Dwight Randy Green. You can hear me now? You hear me okay?
Yeah.
Okay. Right, my name is Dwight Randy Green. I'm the grandson of John Van Scravendite and the homesteader originally there from 1902, and the son of Jean Green, who put in her trust, filed with the state of Idaho that she wanted that property preserved. And we did file lawsuits to try to get her guardianship, and it looked like people were trying to essentially steal her shares. She incorporated in the early 70s, in the mid 70s, because she thought that would be the safest way to protect the property by gifting shares, so that the children would have shares of the property instead of, like, you know, you get this acreage and this acreage. That would keep it intact and keep it from being sold. Now, she thought she did everything that she was properly. She was an intelligent woman. She was a valedictorian of Hope High School, when Hope High School actually used to have students. She used to live with her Uncle Henry, who she assisted, who homesteaded on Pearl Island, and which she assisted in donating to the state of Idaho. If you look at the plaque on the north end of Pearl Island, you'll see that it's been donated by the Van Scravendike family. My mother was a conservationist. She would talk constantly about how she did not want McMansions there. So this meeting should not even be being held. I'm sorry that there are local residents there that have been misinformed as to why there was legal cases brought, but we were trying to protect our mother, and a trust and a will filed with the state of Idaho apparently has no, watch out, you senior citizens, because your land and your property can be taken from you with something called a TEDRA, a Trust and Estate Dispute Resolution Act, which requires nothing more than a filing with the state. Not even a judge has to look at it. And the person that signed for it was appointed by as a special representative by a filing or a petition signed by my father, Ralph Green, who's not an attorney, not a doctor, and didn't even finish 8th grade. Yet that's the kind of stuff that you have to watch out for, and how property gets stolen from people. Now, regarding the road and the high water mark, my grandfather, John, his brother, as I said, was where my mother stayed in Hope when she was going to high school there, and who homesteaded on Pearl Island. He was a surveyor. If you look on a lot of those things, you'll see H. Van Scravendijk. He surveyed all around that area. He taught my grandfather was not a dumb person. He wrote it to go to the high water mark. If you look at the certificate of compliance that was filed with the county in 2020 to move those lots, those 21 lots up, you'll see that those documents that John Van Scravendijk signed back in the 50s mention the high water mark. They don't mention he knew what he was doing. So, and that road, if that road was put in for his agricultural use, riddle me this, why did it not go to his barn instead of the lake? It went to the lake because it went there because the steamboat from Bayview to Sandpoint would get flagged down and come to the dock, and you could use and was used for commerce. That's what navigable waters are for in this country, is for commerce. And as somebody said, well, what he used to do is he used to actually slaughter his own cattle, and he would put them in gunny sacks and flag the boat down. The boat would come in, put them on, they go to Sandpoint. So, there's no way that the road would not go, all the way to, why would you have a road stopping before the water? It makes no sense at all. The other thing that's really important about this is that this application is filed by Green Enterprises regarding parcels that no longer exist. Those parcels were sold last year. It says here that the applicant assigned a locally funded improvement and put money into an escrow account. I have no evidence of Green Enterprises doing anything, put any money into an escrow account. It says here that there's a proposed to construct turnaround. If you're going to get rid of, there's a perfectly good turnaround at the end of the road that nobody has to build. It exists already, and it's been used by snow plows to keep the county road open so that all the residents along Camp Bay Road can have the snow plowed. If you're not going to, have a turnaround, then where the hell are you going to? What are you going to do? Back up that snow plow for 2 miles? You've got school buses that come down there and use that. You've got the United States Postal Service that comes down and use that road. I mean, this is a well-established public road going back to steamboat access for commerce and for passenger traffic. If one needed to go from where, anywhere along the lake, if they wanted to stop, that's where, they could come to there and get on the ferry the steamboat by raising the flag. As my mother said, as long as the captain wasn't too drunk. The other thing too is that it's really important as an emergency access. If you look at the shoreline between Glengarry and Garfield Bay, this is the only other access. And as other people have mentioned, that's when storms pick up on the main lake. That's the widest part of the lake right there. And you've got a lot of boats that come in there for safe harbor. And if they need emergency access, they may not even be a storm. They may need to just, get to someplace as quickly as they can to get somebody off of a boat who's had a heart attack, to get it to an ambulance. And, everything from public access for putting a kayak in to kayak out to Pearl Island, or kayak out to past Mineral Point to get onto the trails, to emergency access for, I just don't know how can you possibly think that this would be a good thing to do to get rid of? It exists. You can't replace it. And this stuff here where I'm just appalled that you've got things in here where the applicant is proposing to do things. How in the world can you possibly have a proposal to construct a turnaround? How can that not even be like one of the, before we do anything, we've got to make sure that we can turn a fire truck around at the end of the road. We got to make sure that we can turn a snow plow at the end of the road. And something, you can do that already because it exists, and it's existed since the 1900s. And my grandfather, John Van Scravendijk, knew exactly what he was saying when he wrote things to say to the high water mark, because he knew darn good and well that that was not something that you could define by an exact, precise measurement, because his brother was a surveyor for the railroads. This wasn't done in stupidity. So please don't vacate the road in stupidity.
Anybody else interested in speaking online? You raise your hand, we can recognize. Reg, is that Reg Crawford?
I'm here. Can you hear me?
Your name, please, record, Reg.
Thank you, Reg Crawford. I'm from Sandpoint, Idaho. I would just like to make a point. In 43 minutes, 37 seconds into the November 9th meeting regarding the cost of the road funds, this is what was said. Could you tell us again the exact cost the county will have to contribute?
Oh, about 820. Yeah, 830.
830,000 total. Why this road over other roads? So I just want to make it clear that for people who have been arguing and it's been denied that those are the funds, regardless if they come in the form of labor or materials, that this agreement with this MOU was entered into to the detriment of other neighborhoods in need of road repairs that don't have wealthy developers moving in. Furthermore, while the district court was still deciding the Arns case, this board entered an MOU with M3 to still be impacting this decision today. Thank you.
Kathy's already gone, so. Who else? Anyone else?
Here. Oh, I can't go again. I have one brief statement that I feel has not been recognized. My mother said repeatedly that she wanted this passed down to her grandchildren and great-grandchildren. This was documented well before Jim had total control. None of the biological descendants voted for this sale. It was Jim and his stepchildren that my parents did not know. If any of you have any sense of family, and I'm sorry, I have nothing against stepchildren, but I do think it's the biological family should have had a say in this, not outsiders. Was meant everything to my mother to know that her grandchildren, her great grandchildren could come and enjoy it. We have been locked out now for several years. Jim's trying to throw me off for trespassing on the property. His stepchildren are welcome. We are not. What does this say about him as a person and his motives? Thank you.
Okay. No one else?
I don't see any other hands up.
Okay, now it's time for rebuttal. Yeah, we're gonna go to close public comments. We'll go to rebuttal. Who wants to go first?
Jeremy? Yep. Mr. Russell will go first and then I'll be brief. Thank you.
Yeah. Make sure you reintroduce yourself. Yeah, it's been a while.
Okay. I'm having trouble sharing the screen. There you go. Perfect, thank you so much. Okay, so the issue, and Allison, I'm sorry, I don't know your last name, so I'll refer to you as Allison, brought up several points regarding the extension of the survey to the lake and to which point it extended to. So she brought up a set of rules in interpreting the descriptions. I call it the rules of comparative dignity. That's how I learned it. I think he used a different term. It's absolutely true, obviously. It's a well-held hierarchy. In this case, the terminus point comes to a point, to quote, it's TP on beach at high water line. So it doesn't say to the ordinary high water line. It doesn't say to the legal high water line. It says to the high water line. We don't know what that meant. We just can't tell what that meant. And I would say because of all of the other factors, you have the tie from that point down to the meander corner and all of the harmony with the road going to the west, I believe wholeheartedly that he came to that very point and he called it high water line. You know, he looked at it. I believe it looked probably very similar to this high water line, debris, some sort of an action caused by a high water event. We looked at earlier, how water would flood up to this point and create this line. And so the idea of, and Allison mentioned accretion and avulsion, I would say that the actual term should be accretion and reliction to change the boundaries. And avulsive action is actually a flood event that changes it drastically in a short period of time, and that doesn't change the boundary. So for it to be an accretive change, that means that the lake would have had to fill this entire thing up to this point, 11 feet, for it to be at the high water mark of 2051. And it's just not plausible. Now, I don't think we know. I think Mr. Marfus put it in his memo. We just don't know what was there when they got there. So we have to look at the other evidence and surmise that he saw something that he called a high water line. So I don't think it's as cut and dried as Allison would have allegedly believed, in my opinion, in my evaluation of the record. So I just wanted to kind of clear that up. Oh, and good point. So I did some research so again, we have records from 1929 through, all the way through today, but 1929 through 1950, the average water line on March 8th was 2048.5. So it would actually be a little bit below this. And the highest point recorded in that same time period was 2051 and a little bit. So very similar to this line. And again, we don't have records, all the way back to 1909, but you give that big, span of time and kind of, cyclical weather patterns, it probably was the same or similar. So I just wanted to clear that up from, from my testimony.
Doug Marfus again, 700 Northwest Boulevard, Coeur d'Alene for M3 Idaho Camp Bay LLC. Commissioners, thank you for your courtesies and attention today. This is a matter of some public interest, certainly. But I think the lesson to take away for purposes of my rebuttal comments is this. I could spend another 3 or 4 hours of your valuable time going through and rebutting a number of the points made today, but I don't think that's a very useful exercise, and I don't think it's very respectful of your time. But I would say this: misinformation is a corrosive thing. We live in a time where misinformation is adopted and passed along and readopted and repassed over and over and over. Sometimes it's for nefarious reasons, and sometimes it's just simply through inattention, neglect, inadvertence, or ignorance of the reality that the person conveying that information must face. I heard a good deal of misinformation today, and that's unfortunate, but it's your job to kind of sort through some of it, all of it, and get to the ultimate decision, which is whether or not the vacation of Camp Bay Road is in fact in the public interest. A lot of the misinformation, and I will refer to it as that because it is that, surrounds this notion that the vacation of Camp Bay Road will deprive the citizens of Bonner County of access, public access to the lake. That is factually false. It is legally false. And it has been demonstrated through the testimony of Mr. Russell and the exhibits that he's created as to why that is false. Words have meaning. You sit in a quasi-judicial capacity, which means in a sense you are judges here today, and judges focus on words. Words like prescriptive easements have very defined meanings in the law. Number of speakers today threw out the concept of prescriptive easements. There is no prescriptive easement here. There is no legal basis for any member of the public to claim a prescriptive easement. And it is well settled Idaho case law in the XREL Fox case from the 1970s that members of the public using property of another, private property of another, cannot establish prescriptive rights for other members of the general public. If anyone in this room, on the phone or elsewhere, believes that they have used the private property that extends beyond the terminus of Camp Bay Road to access the lake and has used it sufficiently to meet those elements of a prescriptive easement claim, they are welcome to bring that claim and litigate that claim and prove to a judge that they have in fact established a prescriptive easement. But that's how it works. Each and every individual must do that on their own account. No one person, no two persons, no 22 persons can do that for the public interest. The viewer report. Number of people commented on the viewer report. Mr. Russell just covered some of it, but it was interesting to watch the evolution of comments and the thought processes that were expressed to you by some of the commenters about what the viewers must have intended. What did the grantor intend? And I submit it's in the record. You can look at it. I can't work this gizmo, so I can't bring it up on the screen for you, but what the ultimate ruling of the Bonner County Board of Commissioners in 1909 stated is that this road will give the people in the vicinity an outlet. not an access to the lake, not a road to a pier, not a way to get to the lake for recreation, for boating, for kayaking, anything of that nature. It will give the people in this vicinity an outlet. It goes on to say they have no feasible roadway and no means of getting to a post office. No feasible way to get to the lake, no feasible way to get to a barge or a steamship or to hail a boater or anything of that nature. This road was laid out, was dedicated by the heirs of the Green family for purposes of giving access to the then residents of Camp Bay via land to the post office. The difficulty, if you will, in terms of the description of an ordinary, or rather a high water notation, I won't plow that same ground. I think Mr. Russell has outlined that for you more than adequately. The fact of the matter is, on that photograph that was before you a short time ago, between those two blue lines was 50 odd feet of beach. That beach is private property. It was the private property of the Green family. It is now the private property of M3 Idaho Camp Bay LLC. It always has been, and it will remain so. Unless the commissioners or any members of the board have any questions.
Looks like you're free.
Thank you.
Jason, is there anything you feel like you need to rebut in your report?
Just a couple of minor things, nothing major. In the public comment, it was suggested that new homes might be polluting the lake with lawns. We already have a vegetative buffer section of our code. A lot of the lawns you see along the lakes and rivers are illegal. It's hard to enforce on them because it's not legal for code enforcement to just walk on a private property, and they haven't bought us a boat yet. But any new homes there would require a 40-foot vegetative buffer with plants from the native and beneficial plants list already in our code. There was comments, concerns about stormwater runoff from any developments. Any significant development on the site would require, and just the same everywhere around the county, stormwater and erosion control plan. That's just standard. There was some comment that as though we selectively did not notice certain agencies. As I went over in my staff report, agencies were noticed as a courtesy. It's not required by law to notice any agencies. And we don't have a value for this because the Bonner County Assessor has determined that the county doesn't value easements. It's not something that they do. Those are the only things that I noted, unless the commissioners had any questions for me.
Any questions for staff? So Matt, we're gonna go back to you. I'll report Jason walking way back up there again. Would you please go over this one more time for the people that and what we're spending as far as the. But I want to make it clear, this is a road vacation. It's not about the development. It's not about the road improvement. While those, I appreciate the questions or comments or accusations. I don't really appreciate the accusations, but we need to remain focused on what it really is. And it's a road vacation.
I'm Matt Mulder. I'm the staff engineer for the Road and Bridge Department. So I was heavily involved in structuring this locally funded improvement agreement that the county signed with M3. And so I'm just going to go over some of these numbers and explain where the money is being spent and by who, just so that's crystal clear, because there's been a lot of numbers thrown around today. So this project is 2.22 miles long, and it stretches from Sago Road down to where Camp Bay enters the M3 property. And the total cost of improvements is anticipated to be $1.633 million, just rounding off to the thousands here. Of that, $802,000 would be covered by M3, with the remaining $830,000 covered by Bonner County. The $802,000 covered by M3 is for all of the, or almost all of the materials for the project, including additional base rock to widen the road, 3/4 minus gravel to add to the surface of the road before paving, 3.5 inches of asphalt on the road, the geotextile fabric, and that's generally about it. The cost covered by Bonner County for materials would be for some rock blasting work and replacing the culverts on the road, which is something that we would normally cover when we're doing maintenance on the road anyway, as well as doing a chip seal on the road the following year after paving. The remaining $753,000 covered by Bonner County would be for the labor and equipment costs for all of this work to be done. So this is salaries for staff, which is already on the books. This is using our equipment at FEMA rates. It doesn't actually cost taxpayers FEMA rates to use our equipment on the roads, but that's what we use when developing these agreements. Okay, I guess that's about it. Does the board have any questions for me on that? Thank you.
Okay, thanks. We'll go ahead and close the rebuttal portion and we'll go into deliberation. No, that's not the way it works.
So before the board begins deliberation, this is Bill Wilson again, but I spoke I usually like to take this opportunity to go over the standard of review. Unfortunately, unfortunately, I guess, because we just came back from the district court, we have the standard of review very clearly stated for us, and I want to repeat that now, just so that we're all on the same page. So when the court, first of all, we know this is a discretionary decision, and that means that the court reviews the decision. It needs to defer to the board on matters in which the board has appropriately exercised its discretion with respect to the evaluation of the public interest. However, and this is just citing right from the case here, the board's determination must be supported by reasoning sufficient to review for an abuse of discretion. To determine if any underlying decision was an abuse, the court must analyze four things. First, whether or not the board perceived the issue as one of discretion. You now do that since I just told you. Second, if the board acted within the outer boundaries of its discretion, that is either approved or denied, of course. Third, if the board acted consistently with the legal standards applicable to the specific choices available to it. We've all been talking about this statute all afternoon and evening now. And fourth, and most important, that the board reached its decision by an exercise of reason. Okay, so that's the one that I want to harp on. The court was not pleased with our last offering and its ability to discern the board's reason. And so we need to do a better job of that this time. And so as you guys go through this process, I ask that you don't just state a belief, but make reference to specific parts of the record, specifically address the issue, if it's relevant to you, of Steve Platt and the road department and the opinion of our new director and engineer, not the engineer, specifically address issues of public the cost savings of the road, if that's relevant. So specifically address, most importantly, this matter of whether or not you believe the public has access to the water based on arguments made by many people here. There are good arguments on both sides made by smart people, and you guys have the discretion to decide which of those you consider most persuasive. I suppose there's a third option as well that you might say that you're not sure. Whatever the case is, I just ask that you be specific about that, identify those specific issues and cite the record. Again, with a discretionary decision, there is no guaranteed right answer. You have the freedom to choose one or the other. Both can be legally defensible so long as you are able to clearly tell a reviewing court, which we're probably going to have one way or the other, why you believe what you do. And we will make sure to have that recorded and correct the errors that the court found in hopes that we'll make a good defensible decision, whatever you choose that to be. Okay.
Good. Yes, except for I got a question on the Steve Platt issue. I mean, we heard a lot of testimony today and we heard a lot of different things, but we didn't hear a lot about the conflict with Steve Platt, a couple little blurbs, and that was about it. So
you know, I mean, so it's pretty obvious to me that Steve had, you know, said, hey, I have a conflict, I'm out, early on. Or the reason this is relevant is because I think in the last hearing, the board, at least in part, based its decision on what it perceived as approval from the Road and Bridge Department. So it's relevant if you want to discuss or the road department's opinions, its recommendation, weighs on your weighing with the public interest. So you need to explain why you think or why you want to give weight to that opinion. You can say, in arguing alternative for a moment, like either I don't trust or don't believe the road department's recommendation because I'm afraid that Steve has poisoned the well, or you can say, I've heard sufficient evidence from Steve himself and also from other members of the department that give me sufficient belief that that recommendation is good and has nothing, it hasn't been tainted by any conflict of interest. So that's the way you would approach that one way or the other. I'm not recommending which way you would. But as you discuss that topic, you might want to go into those details and explain why you either deem the road department's recommendation as credible or not. And the not would be if you found that Steve's involvement at some level made you question the accuracy of that recommendation.
But if we take the road department at their word, which I do, then we don't have to talk about it.
Well, I would still say, I would still say why you,
Because-
if you take them at their word, say why. Because I perhaps I trust the Jason and Matt, to be honest, I trust, or I trust Mr. Platt when he says that he did not have any influence on their decision. You can say that. I don't mean to put those words in your mouth. I'm just saying, I do that.
I get it.
Get into that one.
Sure.
So regardless, we still have to, whether we move to approve or deny, we have to address these.
I would, yes, and even if that's not the determinative issue, say you're moving to, your mind has been changed, you wish to deny. You definitely need to go into the reasons for that, but I would appreciate it if you also go into these other issues and explain what your position is on them, even if it's not something that goes to the heart of your decision. I would still be helpful if you at least address those things, because that was one of the specific reasons that the court sent this back, so we looked at that one thing. That went way longer than I anticipated.
It's usually does. So, okay, with that, I'll start as far as deliberating goes. I've gone back and forth probably 5 times on this issue. And for good reason. I think both Allison and Kobe were convincing, however, the surveyor was also very convincing. Actually, for the first time in my 5 years in office, I'm struggling with it. Normally, I mean, it's easy for me to go and make a determination and move forwards. But I've got a little bit of pause, and my pause is based on determination of the actual high water mark. I think there's good arguments both ways. I think the fact that we're striking number 3 out of finding the fact is giving me additional pause. It's never quite as simple. This one isn't as simple as most that we've dealt with. Can you pull up, I think it's Evergreen, it's right across the bridge. In Sable. You pull it up, you have to do it on the computer up there. Pull the GIS map up.
Evergreen, right?
I think it's Evergreen Way, it's right across the Long Bridge, on the left, on the east side. Whatever that street is, but right next to the old Longford Barbecue.
So I guess
I'll show you the level of significance to this, at least the way I see it. There's Greenwood, maybe it's Greenwood, I'm sorry, Greenwood. Put that on the screen. Can you make sure you light up? Yeah, you light up, yeah. There you go. Yeah. Right down, yeah, close, you bounce a little close. Make you see something. Okay. Go right out to the end there, right where it hits the water. Yeah, right? Yeah, the one above there, go up there, right there, okay. With this, you can see that that road easement goes all the way down to the water. I mean, there's absolutely no doubt. In fact, we got in a bit of a tussle with the neighbor there that tried to block public access to the point where I actually had to go out and deal with the guy. He would park his RVs on there. He would obliterate the trail going down to it. He would do all these things to try to keep the neighbors from accessing what is clearly public access to water. What we finally ended up doing is we built fences, we cleaned it up, we made sure that the public knew that that was public access. And it shows, you can see those clear lines that delineate the public access. We'll offer that we want. Now the guy seems to be backing off. That one's an easy one. We can see the clear lines, the easement, going all the way down to the water. When we go to Camp Bay.
And that's with the water's down.
That's with the water down. When we go to Camp Bay, it's quite a bit different story. We don't see that clear delineation where there's easement lines that go all the way down to the water. And the current map is almost useless because it's got the overdrawn from our decision last year, I think, still on there. And this is where I'm struggling was there truly ever lake access, public access to the lake? Because in reality, just because some folks have gone there, doesn't make it public access. It doesn't even meet the standard for the restricted use.
There was a dock.
I know there was a dock there. Again, and the fact that steamboats used to come in there, it could have been coming there by landowner's permission, I don't know. None of us, I don't think any of us really truly know. But what I'm looking at is we're tasked to stick with the law. And I appreciate everyone's opinion and want to reserve more lake access. And that's great, and I get that. But this is what I'm struggling with is there really public access there? Was there really public access or was there ever public access there? I keep hearing it both ways, and it's got me just a wee bit concerned. Because we certainly don't want to shut up. If there was an established line there, if there was county property there, then this decision would be easy, and we'd say, yeah, no, the road vacation, we're not going to give up county property for public access. But I don't see where that exists, but I'm still struggling with some of the information that's come forward today. You guys have any thoughts on that? We'll take this issue by issue.
Got lots of thoughts.
Yeah, go ahead.
So the one thing that I want to make really clear is that I heard stated a couple times, well, we've given up public access before. That's absolutely not true. As a matter of fact, we have fought for different public access to the water, whether it be Priest Lake, whether it be Ponderay Lake. We are definitely not giving up access. We have multiple launches throughout the county that are in disrepair, and we are not giving them up because they're irreplaceable. The point of the matter is when we heard this the first time, we were told that this by no means touched the water. There was a gap between it so that we were not eliminating public access. So I would have had a probably a way tougher time saying yes to a road vacation if I knew that that was public access to the water. As we move forward, and now we've got a room full of people, let's be honest, at that time, there was only probably 10 or 12 people that showed up to the first hearing. And as a matter of fact, most of those were in favor of it, that lived in the area there, that lived on both sides of that proposed vacation. So, you know, we had a different look at it than we do now. So we are tasked with, is this in the public's interest? So that is really tough. I mean, Mr. Martha said, it doesn't matter, the commissioners can make that decision regardless, that we can give that up. Well, it matters to me. What matters to me is it water access or is it not? And I don't know that I have the answer to that after hearing that.
See, where I'm at, when we heard it the first time, because I distinctly remember going down there doing the job. And as soon as you pull up to where you go left or right, that sign was right there, private property, no trespass. That would make one tend to believe that it's private property. That was never contested the first time this came before us. But today, we got a full history of that access. And quite possible that the boats were the public access before the road right of way ever came into play. Because the road right of way came into play after it had been settled. And for years, it was used as public access after the road became a road right of way. Historically, it has always been access going both directions. The intent, when the land was donated, was stated in the one report to get to the post office in town, or where the post office was at that time. So you got some historical data there that shows some intent, and then you've got some historical data that has always maintained it as commerce thoroughfare. And regardless of where the high water mark, the average high water mark, the low high water mark is, you would never build a road to the edge of the water, because that end of the road is going to get washed and beat up and deteriorate. So you would stop just above that with building the road. But the access had always been there. So as to whether or not it was ever legally posted is a major question for me. But like the other one that we brought up and showed you, that one's a no-brainer. You can see it goes right off into the water. That's public access. This one is not so easy. That's probably the hardest one we've had. And at the end of the day, we have to follow the law. Now, when it came back from the court, I believe that decision spoke to Steve Platt, and that had not been brought forward to the judge's satisfaction. So I'm going to touch on that now. Steve Platt has came testified today that he did recuse himself so that he was not attached to it whatsoever. I am satisfied with the fact that he did not influence this plus or minus or against. He stayed completely clean of it. I'm convinced of that. I'm comfortable with that. Road and Bridge is comfortable with that. I don't think any of y'all actually contested what he said today, because I didn't hear oohs or ahs or boos or anything like that. And y'all are usually somewhat vocal. And for the reason of the historical facts of how it's always been used up until the last 30, 40 years, whether or not it was legally posted, I don't know. But for that reason, I would be compelled to deny this vacation. I would be compelled to do that, simply on what I've heard today.
Yeah, I want to go ahead and speak to Cloud issue as well. Steve, if I recall correctly, I think Steve came to a monthly workshop. We have a road picture month update, and it's on the record. He made the declaration months before this issue even came up about the vacation. Plus, I've known these two men now for 5 years, and I know that I trust their word as well. I believe their recommendation. I see the struggle that Jason has, because I'm kind of in the same spot. I see the reasoning behind it. We have an issue with gravel roads in the county. We've done a number of studies. see how problematic and how expensive they are to maintain, especially one that's not a full width road, one that's got some topographical issues to it that seems to cause a lot of issues. So to me, it's easy to make a case there with respect to public good, and it's a pretty broad public good. And I did want to remark on one thing. One of the ladies who testified said that the $2 million homes are going to increase taxes. It's not the way taxes work. Actually, taxes work, property taxes work. What we do is we have a hard number. We go out and it gets divided amongst all the homes. So literally, newer, more expensive homes will reduce the amount of taxes that everyone pays. It doesn't increase it, actually reduce it. We dilute the hard number that comes from us, about 46% of our budget out over more properties, more expensive properties. So actually, it's the benefit goes the other way. It actually does help taxpayers. As far as the road itself goes, that would become taxable property. Benefit there. But I'm still struggling with this high watermark issue. And Bill, do you know anything about this issue? About the high water, the arguments on high water marks. I'm really having a hard time with, who's right.
So, like I said, my opening statement for your deliberation, I think you received advice or you've seen.
So you're telling us you're not going to tell me.
I'm going to say that I can't sit in a position to adjudicate or decide which of those arguments is best. The truth is, it seems like you're right. The previous hearing, there was very little, if any, discussion of to this level of depth. It almost seems like we're attempting to shoehorn a quiet title action of some kind into a vacation proceeding. It would be great to have this answered or have this question answered by a court.
I agree.
That would be like the best case scenario, where these issues could get hammered out, because it does seem as though you guys are. I mean, in the previous hearing, we focused on benefits like tax reduction and paving and stuff, but it does sound as though you are now turning to whether or not the public has a right, where some people say it exists and others say it does not. I don't know if anybody in this room can conclusively answer that question, but the best we can give is educated opinions. And these guys are more educated, better to give that opinion than I can't act like I know that.
I better weigh in before I forget about Road and Bridge Department, and I've worked with the Road and Bridge guys for the last 5 years. Have total confidence in their ability to judge the situation, and believe that if that does not touch the water, if we do not have public access to the water, it's kind of a driveway. And to say that, well, let's just keep it because I'd like to drive down there and take a look at the view. I don't know that that's a reason to not vacate it, but the lake access to me is the kicker. I'm just not comfortable that I can say that it's been answered.
And that's why I'm saying I'm in the same spot. I'd love to see the court sort this out.
So if that's your decision, you still need to make a decision on the application today. So you still need to decide whether or not you want to make it. It sounds as though you're uncertain with that, yet say no. But you have to. It's not. I don't think it's a viable option to say we're going to wait for a court opinion. So you have to make a decision now and then allow things to play.
I want to say one more thing too. When it comes to making decisions like this and in respect to some of the public comment, we hear it all the time. If you don't decide my way, we're going to make sure you're on the elected, we're going to put you out, whatever. Those factors never weigh into a decision I make. I'm never intimidated by threats like that. It doesn't affect me anyway, because if it did, if I allowed it to, that would be akin to taking a kickback. You're threatening me with a service you're saying you can do. If you decide with me, then we will make sure you get reelected. Whether I get reelected or not has no bearing here. It shouldn't if you have any integrity. If you don't have integrity, then I can see how a person can be swayed. But if you have some integrity, what you do is you look at this as, I'm here to make a legal decision. I'm not here to feather my own bed by hoping to get reelected by people. So while I can't stop you guys from doing this, which we haven't seen anybody stop yet, it doesn't sway, those kind of things don't sway us. What we always look for are, give us some facts, give us something we can hang our hat on for or against. That's what we look for as the commissioners. We look for a reasonable legal reason to either move for something or against something. So in the future, keep that in mind. If you want to get a witness, it's your right to, that's awesome. But it doesn't sway us. If anything, just human nature creates some animosity within, you're asking us to side with you while you're threatening us. That whole how to win friends and influence people thing, don't quite fit with that. So what we always look for, give us something we can hang our hat on. And at this point, I can't hang my hat either way until I find out what's going on with this lake access, whether it truly exists, or who's right. I have no reason to distrust Allison and Toby. I think they're honorable people. I also have no reason to distrust N3's attorney and their surveyor. So I'm at a quandary.
Yeah, so I'm gonna just go a little further than you did. I know we've had a lot of comments about, well, we don't want McMansion, we don't want Californians controlling it. We don't look at that, or at least I don't, I'm sure neither. I mean, our job is to try to just look at the information the best we can, and make a decision, and we don't look at how big their house is gonna be, what they drive, or anything else, and where they're from. That's really irrelevant to what we're trying to decide. And just so the public knows, I get it. I lived here my whole life too. I get a little cranky when it's safe when I can't get out on the road or whatever, but that's growth. It's coming.
So I think given the information, I'm sorry,
I'm trying to be.
Okay. Given the information by our attorney, at this point, I don't know that we have any other move other than to deny, and then hopefully M3 can get something adjudicated in the courts that tells us yes or no. And for that very reason, because I think the legal public access to the lake is yet undetermined. As you heard today from both sides of the lake. So my recommendation would be that we would deny the petition for now. Hopefully, M3 can provide us with some adjudication, or even the other side, if you guys want to get together and see if we can approach the judge, so that we can make it a move, we can make a different move if we need to. Or not. I mean, again, I can make the public good argument all day long, because we know our basis for public good, unless people kind of skew that whole what does public good really mean. Public good doesn't mean that everybody likes it, or everybody's happy with it. We strictly look at it primarily from a financial standpoint, maybe the health standpoint. But that would be my recommendation. We need to deny because we haven't seen a determination yet on whether truly there is legal access or not. I think that's I judge. Guys have any thoughts on that?
Yeah, I think it'd be great if the court would say, yep, they had legal access, or no, they did not. It would make it much easier, because then it'd be easy to go, you know what, if we can get 2.5 more miles of Bonner County road paved at half the cost, where's the downside of that? But without definitive answer as to whether or not that access legally exists, I'm gonna have to make a motion to deny.
If you've seen us in planning hearings, we're rarely very indecisive. When it comes to these things, usually it's black and white cut and dry, it's the law, that's it. This one definitely has good stuff for the first time in 5 years. Jeff, you have anything you want to add?
I think I said it. Haven't I, Bill? Have I covered it? You have, given that you're moving to the motion has been made to deny. Just do that.
We haven't read it.
Yeah, okay. I do think you guys have, this has been a good discussion that will allow the court, if it has to understand the reason for this decision. That's the most important thing. I think. Well, yeah.
So I'll entertain a motion then, deny.
All right. I move to deny this petition file VS0002-21. Petition to vacate a 2,550-foot portion of Camp Bay Road as shown in the submitted site plan based on the following conclusions. The decision is based upon the evidence submitted up to the time the staff report was prepared, testimony received at this hearing. I further move to adopt the previous findings of fact and conclusions of law as set forth in the staff report as amended during this hearing, and direct planning staff to draft written findings and conclusions to reflect this motion. Have the chairman sign, record, and transmit to all interested parties. This action does not result in the taking of private property. The action that could be taken, if any, to obtain the vacation is to file a new petition with the planning department, meet standards required by Idaho code, or pursue such remedies as may be applicable at Idaho Code Title 40, Chapter 2.
I'll second the motion.
Okay, we have a motion and a second. All those in favor say aye.
Aye.
Aye. Motion passes. Oh, I'm sorry. Roll call vote. Yeah, that's right.
Commissioner
Aye.
McConnell. Commissioner Conley.
Aye.
Commissioner Zephyr.
Aye, and
And it's only 6:05, and we're going to 6:04. We're going to go into adjourn this evening's meeting.